Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Good morning, Justice Serve TV family. Sorry, I'm a little late. The StreamYard knocked me off, but I'm back because I'm determined to be with you on day 23 of the Karen Reid trial. As you know, I'm Linda Kenney Baden. Now, before we discuss what's going to happen today, I wanted to play a very short clip of something that happened yesterday, and then I have a rant.
Whether this was caused by a car accident or not. Did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a conversation with Dr. Scortabello about her expertise limitations?
No, I would want a biomechanical analysis.
Was your
A person like that. Let me say it again. A person like that. Let me say it for the third time. A person like that. Welcher was talking about Dr. Irini Scortabello, a board-certified forensic pathologist who was the state medical examiner assigned in this case. And her opinion was that John O'Keefe, there was no indication that he was hit by an SUV, a 6,000-pound SUV, especially one traveling 24 miles an hour. It was her opinion that she could not determine whether this was a homicide or not because what he died from was a fractured skull in the back, okay? And then this man, who is an accident reconstruction, who left medical school after one course because he didn't want to do that, he says, and now claims, and he probably is right, that he's a board certified, or not, he's not board certified, just certified biomedical engineer, of which biomechanical engineering is a subspecialty. But he asked whether or not he would talk to Dr. Scortabello or consider her opinion. He said, I wouldn't talk to or consider an opinion of a person like that. Well, sir, you are talking about a lot of people I know, and you're talking about a lot of forensic pathologists in the United States of America whose job it is you wouldn't do in a second. You wouldn't spend 30 seconds in an autopsy room doing an autopsy. You wouldn't spend a minute talking to the families of people who died from under suspicious circumstances. And when you say a person like that, she went to school, she went through education, she went through a residency, she was assigned to a medical examiner's office for years to complete her degree, to complete her requirements to get board certification. Then she sat for a test, and she's probably sat for a number of tests to say that she is an expert in the cause and the manner of death, which you, sir, are not. That is my rant. You know, I take this very personally. Why? Because my husband is a board certified forensic pathologist, a board certified anatomic pathologist, a board certified clinical pathologist who went through years of school, internships, residencies, special training programs. You know him well, Dr. Michael Baden. All right. So when you demean someone like Dr. Scortabello, you're demeaning all forensic pathologists in the United States, including my husband. Sir, I have no respect for you. After that, I will listen to you today, but I will not listen. I will tell you with an open mind. That is my rant for today. Judson Welcher, bye-bye from Justice Serve TV. Now, with that out of my system, because I have been stewing about that ever since I saw it, and I apparently missed it yesterday, let's talk about something else that just happened last night, okay? And it is major. It is the opinion that came down from Judge June. Oh, there he is again. You want to hear it again? You want to play it again? Let's hear it again so people know what my rant was about. Let's play it again before we go to the other one. What happened last night with the Federal Circuit Court. Oh, actually, we're gonna do this. Can we increase that just a little bit? This is Judge June's opinion. And recall last night on the show when we had Aidan Carney on the show, who was, I will say, a pleasure to have on, an absolute pleasure to have on. He answered every single question we had. He was gracious. He was respectful. And you know, You watched him. We had about 10,000 people watching Aiden. All right. We here at Justice Serve TV have come to determine that we support him. All right. Because of the work he is doing. But let's talk about this opinion. As you know, Jason Grant, the lead plaintiff in the name of the suit, was on TV the other night. He, and along with Michael Bryant, along with Tommy DeRozier, and you heard John Matus, the other local attorney in Massachusetts who does First Amendment work, Mark Randazzo, the Center for Liberty, who is supporting everyone on this case. Erica Walsh, who was walking down the sidewalk wearing a sweatshirt that said criminals run Norfolk County, which is something you could buy on Richie's site, Microdots TV. Let's hear. Here's the memorandum. We weren't sure it was coming down because we knew that Judge June was going to be away on vacation. But it's forevermore going to be Jason Grant versus the trial court of the Commonwealth of Massachusetts, Beverly J. Cannoni, okay? And then Jeffrey Noble, the superintendent of the Massachusetts State Police, along with the town of Dedham, and Michael Morrissey in his official capacity. Jason, by the way, we're going to try to get him on our show tonight about 6:45. We have Stephen Plord, the accident reconstructions, on our show till 6 o'clock. At 6 o'clock tonight, and we're going to try to get Jason back along with Mr. Matus back. But they talk about, this is just the first page. We can go to the second page about the suit that was filed. And you know, Jason was wearing a biblical verse from Corinthians, all right, which just talked about freedom. And he's been going there every week since November of last year. Can we get to the second page or not? If we can get to the second page, that would be great, of the memorandum of opinion. And the judge recounts the buffer zone orders. Now, let me cut to the chase. I will go to the last page because we will have time later on to do this to do every single page. And I think it's very important if we do every single page. But let's go to the conclusion. For the reasons shown above, plaintiff's motion, that's plaintiff Jason Grant and the other two. And it also applies, by the way, to Michael Bryant's case and Tommy DeRozier case. The judge made that very clear. The motion of temporary restraining order and preliminary injunction is denied and in part and granted in part. Now, what does that mean? That means that he found the buffer zone can stay, but the enforcement in the buffer zone, goodbye, so long, farewell. Law enforcement officers are enjoined from enforcing the buffer zone orders in ways that are inconsistent with this decision. Prior to enforcement, law enforcement officers must be able to clearly articulate without speculation how any individual violated the buffer zone orders consistent with this decision. Now, what he said was Erica Walsh's sweatshirt, which just had criminals run Norfolk County. Fine, no problem. She can walk in the buffer zone up and down all she can. You can't have a FKR because the judge held that FKR comes to stand free Karen Reed, and that can't happen. Of course, if you're supporting Robert Kennedy, I guess you could have an RFK there, and they can't do anything about that. All right. And this is very important because it also held that, that Jason Grant could have his sign in the buffer zone. He doesn't have to worry about stepping off the sidewalk. And it also said that the most important thing for us, for Michael Bryant, who was one of the early plaintiffs in the case with Tommy DeRozier, Tommy CPU, by the way, who now really has a case against the Massachusetts State Police for picking him up and bashing him down. They can go, all the journalists, anyone gathering information to put on news and to put on, to mediaize it, I'm going to say. And that's us. That's Justice Serve TV. That's Michael Bryant, all right, are free to go in the buffer zone at any time and do whatever gathering they have, okay? So I want to applaud Michael Bryant because even though he is my partner, remember, he started this when, it could have gone either way. If you recall, I was on the air when he was through the buffer zone with Tommy DeRozier and Mr. Delgado, and Delgado had something ripped off his jacket. Tommy DeRozier also was told that he couldn't come in the buffer zone, but Michael J. Bryant, Trooper Hardman said to him, sir, now he didn't really say sir, I'm just giving him credit. Mr. Bryant, sir, okay, now let me cut that. He said, I've seen you go past here 5 times. I don't want to see you walk this sidewalk again. I am, those are not the exact words, but that was the tone, that if he came back, Michael would have been arrested. All right. Michael did come back. All right. And he did go into the buffer zone to get statements from Karen Reed when she was leaving the court. And we had, as you know, we had some statements that were given just to him with his Justice Serve TV mic, not in the whole scrum. So, but now he can go back freely when he goes back Wednesday of next week and Thursday of next week. And he was discussing that he was a little worried because, you know, they're just arresting people. They didn't care. Well, now they can't. They can't arrest Michael Bryant. They can't arrest Tommy DeRozier. They can't arrest anyone as long as they're in the buffer zone and they're expressing their free speech with something that doesn't say Karen Reed on it, that particularly applies to Karen Reed. This is a huge decision that Judge June had. Now, while I'm sure everyone would like the buffer zone not to be 200 feet, but it means that everyone with the lounge chairs can go into the buffer zone and say, you know, we are protesting government. Government is too big. Government in Norfolk County is wrong. I mean, if you want to go to Richie and Microdot sites and buy his merch that says framed, I think that's okay. Although maybe a little more questionable, but certainly criminals control Norfolk County. You could have 100 people wearing that sweatshirt. That's no problem. You just can't make noise. You can't disrupt people. And if you're going to start arresting people, you have to have a clearly delineated reason why that arrest happens. Big decision. I applaud the Center for Liberty, who out in Las Vegas, who supported Mark Randazzo, who supported Michael Bryant of Justice Serve TV, who supported Tommy DeRozier, who supported all of these plaintiffs that felt the need to go against big government, against our First Amendment rights. We won, okay, which means you won. All right. And you should be thankful to them, applaud them, really, you know, go to Tommy's site. Tell him you thank him. Go to Mark Randazzo's site. If you can find yourself to give a donation, I know he's going to put out a link to them. We certainly are, because they did this because they believe in your rights to the First Amendment and all. All right. Now, with that said, I'm looking at the fan. I just want to tell you, and Joanna Goddess is here. You know, Joanna, she says, I love the hoodie, Linda. I just ordered the same one, but the other design. Yes. I just want to tell you, not that I should be hawking merchandise, but I am, because, you know, I love shopping. I just got these. This is Dizzy designed this hoodie with Justice Serve TV and all the different colors. There's some great colors. She has I'm going to buy them all. I will say to you that I wear a size small. They're unisex, so if you like a little bit of extra room in your hoodie, a lot of people like to put things under. They run shooter size. If you want to be tight fitting, you should get a different size, maybe a little smaller. And I'm also wearing, by the way, Justice Serve TV pants. I don't know if you can see them. I can't tell. There they are. See, and they're unisex.
The
and
Dr. Shorty Bello aspect of
okay.
Dr.
Let's
Welcher.
go into court. Well, I'll say hello
With
to you.
regard to Trooper Paul, I would like to draw the court's attention to the following documents for the straightforward proposition that Dr. Welcher has not only reviewed, he has not only considered, that he has adopted. I went back and looked at the documents, and the basis for this is as follows. Slides 22 and 23 do not just depict Trooper Joseph Paul himself. They show Trooper Paul conducting the CARS analysis on February 1st of 2022. Importantly, these slides highlight the mileage odometer of 12,665, and I respectfully request the court to anchor into that odometer reading, because I'm going to show the path that that odometer reading takes through all of the documents, but I want to emphasize the genesis of the odometer reading of 12,665 miles is with Trooper Paul as he conducted the CARS analysis on February 1st. Now, here's where Dr. Welcher comes in. Dr. Welcher then uses this key data point, odometer 12,665, as the basis, the starting point for his determination of the locations and times for the events of January 29 of 2022. Dr. Welcher uses his scenario analysis of Ms. Reed's travels, and that's detailed on slides 24, 25.
This is out of the presence of the jury, by the way.
27 and 28 to calculate and then deduct 36 miles from the odometer, according to Trooper Paul on February 1st of 2022, to arrive at an odometer reading of 12,629, which obviously is different from the anchor I talked about of 12,665. So the assumed odometer of 12,629, again, is based on Trooper Paul's CARS analysis in slides 22 and 23, are then used as a tether, a connection to the events recorded by the VCH in the Lexus on the following slides: 28, 29, 30, 31, 32, 33, 35, and 36. I elucidate this and I explicate the slide numbers to show how many there are in Dr. Welcher's report that are rooted in the anchor point and then the change in the deduction of the odometer. So the events memorialized by Trooper Paul on February 1st, including the odometer reading, provide the foundation for Dr. Welcher's entire analysis of the VCH events. The entire analysis of Dr. Welcher's VCH events. That is the adoption aspect of what I started with. Two more points. In addition, Dr. Welcher testified on his voir dire that the image on the left of slide 36 from his January 30th, 2025 presentation came from a file marked carsj.paul. Now, he did contend that it wasn't the exact same image, but I want to go to this. In fact, the image on slide 36 is from the drone used by Trooper Paul, and the citation for that is page 4, item 11 of the CARS report. That's where the drones are from. Dr. Welcher didn't do any drone activity. He took the drone that he had in his report that was just a little bit different than the one I was showing him. It comes from page 4, item 11 of the CARS report. And I quote, "The crash scene was documented during the on-scene investigation by utilizing Alicia's GNSS GPS mapping system and a DJI Mavic 2 UAS. This data was input to a computer-aided diagram program, which is IMS 360. Here's the key: to produce a scale diagram of this collision. So the DJI Mavic is the CARS team drone. This image of Dr. Welcher's slide 36 is clearly and indisputably from the drone. And the only drone extant is the drone of Trooper Paul and the CARS team. Last point with regard to the Trooper Paul basis in adoption of Dr. Welcher. Mr. Brennan asked Dr. Welcher on voir dire if the image from slide 36 actually came from the CERT team, which is simply not true. The CERT team, actually Lieutenant Tully with the CERT team, took about a dozen photos of the taillight in the snow in the dark around 6 p.m. on January 29, 2022. Lieutenant O'Hara said that the CERT team never traveled back to the scene again. So there were very obviously no photos or images taken by the CERT team in the daylight from the drone. And I again refer to slides 22 and slides 23, where Dr. Welcher said it was more likely than not that it was Trooper Paul in those slides, but the point, whether it's Trooper Paul or not, is completely overwhelmed by what I just argued and presented as specific factual basis for a review, a consideration, and an adoption of the work of Trooper Paul. Unless Your Honor has any questions, I would now move on to Dr. Scorti-Bello. Thank you. Dr. Scorti-Bello will be much shorter. Mr. Woke, do we have the slide of the Dr. Scorti-Bello it's at the end of the slide presentation with her name on it? Oh. You just give the slide number, please. So it is slide 131. I almost know it verbatim, Your Honor, so I will continue. If Ms. Gilman has slide or someone could turn it on. Okay, thank you. Thank you, Your Honor. So with regard to slide 31, at the very top, and this again is a slide presentation of Dr. Welcher. So up at the very top, and so Dr. Welcher admitted that he not only reviewed the autopsy report, he admitted that he not only considered the autopsy report, he admitted that he adopted it, and I'm going to put adopt in quotes, to the extent that he used it in his slide presentation, and he actually, to show the depth of those three verbs, he's got in orange highlight under final diagnosis, multiple skull fractures, base of skull, and cavallarium. He testified, obviously, about the rear wounds of Mr. O'Keefe. He testified about how he believed those wounds came about, and he cited as corroboration the highlight of multiple skull fractures, base of skull, and cavallarium. It couldn't be any more obvious, his rooting in this document and reliance upon it. Why else would he have it in his slide presentation? And he's got the name of Dr. Scorti-Bello. And frankly, Your Honor, he didn't fight that whatsoever in the questioning of him. Then you go to underneath cause of death, blood impact, injuries of head, and hypothermia. He essentially repeated that on his testimony. And then if we could, Mr. Wolk, just go to the right. And so you've got highlighted head, skull fracture radiating from the right occipital skull and into the right parietal bone, right and left occipital foci, and bilateral anterior foci and orbital plates. Again, the highlighted means something. He's adopting it. And lastly, the depiction of the skull here, I believe that's Dr. Welcher's handwriting. I believe that's his green, the LR, because I've never seen this green highlighting before. And it could also be Dr. Scorti-Bello's. That's another possibility. I'm not sure. But let's assume sort of the most conservative part that it's Dr. Scorti-Bello's. The key part is he's got it in there and he is referencing it. So, Your Honor, the last point really for both of them, and I wanted to save this point because it applies to both. With regard to experts, the law is clear. So I think the easiest part to show what our position here is the adoption. But in it, it's clearly shown. Adoption doesn't mean you have to agree with it. You just have to put your expert hands around it, wrestle with it, deal with it. And there is no rule of law that I'm aware of that says you can't question an expert witness unless it's something that the expert witness agrees with. If the expert witness has reviewed it and considered it, and especially if they've rejected it. The easiest is obviously reviewed, considered, and adopted, but it's certainly permissible and important to a defendant's constitutional right, Sixth Amendment to cross-examination, if an expert says or even infers, I reject this. I reject what Trooper Paul did, or I reject what Dr. Scorti-Bello did. That is decision-making of an expert that the attorney has a right to be able to test. Why did you reject it? What was your thought process in rejecting it? And that applies to both Trooper Paul and Dr. Scorti-Bello, because as I understand it, this witness, Dr. Welcher, is not, he says, I'm not relying upon Dr. or Trooper Paul, which is completely false based upon what I just showed. But even if he just rejects it, in addition to what he has done, we have the right to test and get answers as to why he did it. And the same with Dr. Scorti-Bello. Once he goes to this level, Your Honor, I believe it's a straightforward right, especially of a defendant in a criminal trial, and especially of the stakes and the charges this high, that we get to test it. What I think, lastly, my point here, Your Honor, the Commonwealth is doing is this. The Commonwealth knows Trooper Paul and Dr. Scorti-Bello are problematic for their theory and their narrative. Trooper Paul has got, if you work backwards from his key cycles, you end up with 1162.2, their key cycle. That ends up being not in front of 34 Fairview, but it ends up when the Lexus is in the possession of the state. That is the result of that. And that was something that was addressed square head on in the first proceeding. We're not coming up with some fanciful ghost in the second trial. This was gone through extensively in the first proceeding. And I understand this is a new trial, but it goes to show it's not something coming out of the blue, etc. And with regard to Dr. Scorti-Bello, it was remarkable on the redirect that I've never seen a prosecution essentially go after the opinions and conclusion of their own medical examiner when they basically said, the medical examiner, I can't call this a homicide. The manner of death is undetermined. And the medical examiner says, I don't see any motor vehicle impact injuries. There couldn't be anything more apt, more probative than whether or not the injuries to the decedent are from a motor vehicle. The Dr. Welcher himself is saying they are. That's the essence of his opinion. It's the essence of his test. We get to be able to respectfully, Your Honor, say, well, wait a minute. You said you looked at the autopsy. You said this. You highlight it. But you're going against the medical examiner on whether there's motor vehicle injuries. The experts can't, Your Honor, cherry pick and choose from documents. They can't use it as a shield and a sword. They can't put up, for example, Dr. Scorti-Bello's autopsy report, cherry pick things that benefit from them, and then and they did it on direct. And then all of a sudden on cross, when we want to go and test that, they say, oh, no, you can't do it. Your Honor, this whole argument is absurd, and it's antithetical to the Sixth Amendment. And even if, and this is my last point, even if this were merely a civil case, this would be routine cross-examination against the expert on the side. So in conclusion, Your Honor, I respectfully request that Ms. Reed and her team be allowed to exercise their constitutional right to cross-examination, the keystone of a defense in a criminal trial, cross-examination. and that they be able to take the shield that the prosecution is trying to put on us and be able to combat the sword that the prosecution has put forward with regard to trying to cherry pick from this information, and that we get to proceed, and we get to proceed undaunted from all the serial objections yesterday that interrupted my cross-examination. Thank you, Your Honor.
Go, Alessi. That's exactly what we said last night. I'm glad he inserted the constitutional right.
What arises from the litany of complaints by the defense is that there is no constitutional right to usurp the rules of evidence. There is no case law, as much as they urge the court and yell out the word case law and constitutional right and Sixth Amendment right. There is no case law to support what they are trying to do. It is a simple endeavor that is clouded by all the rhetoric that they offer. And it is clear, and the court knows what they're trying to do. They are trying to pit the inadmissible opinion of a non-testifying witness against a testifying witness. They have asked Dr. Scotibello what her opinion is. And although it's not consistent with our reading of the case law, they were allowed to introduce that it was an undetermined cause of death or mechanism. That evidence is already in front of the jury, but they can't simply repeat it because it sounds good to them or they think it's helpful. Simply because a witness uses a document or looks at it or uses part of an autopsy does not let them regurgitate an opinion that's already in evidence to try to phantom cross-examine an expert. Dr. Welcher is clear. He did not rely on Dr. Scotibello's conclusion that this cause of death was undetermined. In fact, as an aside, he said, I wouldn't, because she's not qualified for that. And so this is a simple game. Let's pit one witness against the other.
It's not a game, Hank.
Commonwealth's witnesses are inconsistent. They take it a step further. They want to relive what they think is their past success last year in this case without actually calling the witness. They want the jury to hear their perspective that a past witness had confusion in his analysis, but they don't want to call the witness. They want you to allow them to do that, not just shouting it out and have sustained objections, which has happened this entire case, but they actually want you to be able to allow them to ask Dr. Welcher these questions, which he did not rely on. We had a voir dire. He was clear. He did not rely on the analysis of Trooper Paul. He did not rely on that determination or undetermined determination by Dr. Scotibello. It is that simple. They try to throw some fluff out and they throw around some documents. We have slide 22. Simply because there's a suggestion that Trooper Paul might be the hand in the picture is not an anchor. It's not a tether. It's not an adoption. It's no such thing. In fact, if you look at that photograph, it was taken by Zach Clark. So by the rationale of the defense, they should now be able to ask Dr. Welcher any question they want about Zach
who took
Clark's
the photograph. The
opinions,
important is who's in the photograph.
That he considered, not an opinion, not an analysis. It has nothing whatsoever to do with Dr. Welcher's analysis or opinions. In fact, the evidence is to the contrary. He came out, conducted an independent analysis, did all of the work himself, considered documents, and he was specific about what was part of his opinion and what was not. And this information was not part of his opinion. They turned to the Google map. Bit misleading. This was generated by Google. Two separate people used the same program, but when you look at the CARS report and you look at Dr. Welcher's PowerPoint, it's different. Dr. Welcher's has a map on the side, and when you look at the numbers themselves, the CAR report says minimum 36.1, maximum 38.8. Dr. Welcher's slide, 37.9, 38.1. So in no way did he adopt, anchor, tether, use as any basis. In fact, his is different and separate, as all of his analysis is. And so the portrayal of this necessity of information so they can sneak in inadmissible opinions with no witness is simply improper. There is no case law. There is no legal support for it. They cannot reach back into last year and manipulate a witness and ask him about something that he didn't rely on because it feels good or it sounds good for their case.
Manipulation
Dr.
is something
Welcher
you,
did not
Hank Brennan,
rely
know a lot about
on Trooper
at this
Paul's
point.
analysis or reports, and he did not rely on the conclusion of Dr. Scotibello of undetermined. If they want to call Trooper Paul, well, maybe they can try to do that, but Dr. Welcher is not the right witness for it. These opinions to try to do a credibility eval is a core preclusion in criminal law, a core preclusion. You cannot vouch for the credibility of another witness. You cannot comment. It's like asking, did the police officer lie when he said the light was red? It's the absolute same analysis. It just has a lot of icing on it.
Very briefly, bring the jury, start getting the jury ready, please.
Your Honor, with regard to Trooper Paul, Mr. Brennan did not address 80% of the slides that I addressed that showed the basis. When he talked about the picture, making it seem like the picture is the only thing we're relying upon, there's clearly other items, but even the picture, Your Honor, the purpose of the picture is it's got the odometer reading. That's why they took the picture, and that's the tether. So the photo is completely relevant. It's not who's in it, it's the fact that that's the odometer reading they're using. Next point with regard to case law, Mr. Brennan presents none to go against the common sense law and that has been there for years. The other thing, Your Honor, is with regard to Mr. Brennan keeps trying to put my arguments into a credibility, like we're trying to attack the credibility of Trooper Paul. He says that we're trying to redo last trial. To the contrary, Your Honor, it's the Commonwealth that brought Trooper Paul into the second trial through Dr. Welcher and Dr. Welcher's reliance on all the work of Trooper Paul. They've brought it in here, and because of that, we get the right to cross-examine it. Last point.
She's going to deny this. You watch.
About credibility. He keeps saying something that's not happening, that we're going to attack the credibility of Trooper Paul. What we want to do is to say to Dr. Welcher, you have brought up Trooper Paul. You have used his odometer reading. That odometer reading tethers through to Google. It tethers through everything you're doing. It's the foundation. But what you're ignoring, Dr. Welcher, are all the key cycle results that come from that odometer reading that you relied upon. Dr. Welcher himself can't cherry pick, grab things that he needs from Trooper Paul to do his analysis, and then the Commonwealth say, but you can't go after that because it somehow has Trooper Paul's name on it. It's illogical, Your Honor, and it's incorrect under the law.
And it's a violation of the Sixth Amendment for a fair trial.
So I disagree with you, Mr. Alessi.
Told you.
I'm not allowing in the line of questioning regarding Trooper Paul, and I'm not allowing the line of questioning regarding Dr. Scorti-Bello. So that's my ruling. Let's bring the jury in.
Told you. Totally wrong rulings, especially when it comes to Dr. Scorti-Bello. You cherry pick what you like out of her report. All right, go on to the sidebar. I am furious here. Okay, I told you yesterday she wasn't going to allow it in because she's going to rely on the specific rules of evidence that you can't bring in another expert as opinion in some way unless the expert on the stand says they relied on it. That's a very technical argument. This is much different. This is a very sophisticated argument, but it's very clear. Let's talk to Dr. Scorti-Bello since I just did my rant on that. So he picks two things out of her report he likes, but then says, you heard he wouldn't talk to a woman like that. Well, he didn't say woman, but I think that I'm going to just say right out, sexist. Okay, maybe sexist. I won't say the last X word. Sexist. So he wouldn't talk to a person like that. All right, demeaning the female medical examiner. Okay, the state's been doing that a lot, haven't they? All right. And that's really personal to me, as I told you. But then he cherry picks that and won't let them go into the fact that she didn't call this a homicide. And then with Trooper Paul, absolutely right. That key cycle we talked about yesterday also keys into when the Commonwealth had the car on the specific ramp, when they were doing the 3-point turn to get it on the ramp. So he's cherry picking that. He's taking an odometer reading, but they won't let them go into why that odometer reading was important. This is a violation of the Sixth Amendment, her right to a fair trial. She is getting railroaded. And quite frankly, if we weren't a free Karen Read, we would have talked about this. Our show on Justice Serve TV is, can the state prove this beyond a reasonable doubt? I'm starting to turn. I'm starting to say free Karen Read, because this is a modern day, shall we say, hanging in some way, hanging of the truth, okay? We already had to go to the First Circuit on the issue of the First Amendment, all right? This is simply outrageous, 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 outrage. I can't say it enough because I know I'm dealing with whatever you said, but whatever you feel. But I did tell you yesterday she wasn't going to do it, relying on the specific issue in the evidence code, which says you can't get into another expert's opinions or findings of fact unless you have adopted them in your report. And that's a very technical reading when you have an expert here that is cherry picking. Okay? And you have a prosecution that's supposed to be seeking the truth. That is the duty. The duty is not to convict Karen Read. The duty is to seek the truth. And she's not allowing us to seek the truth. And finally, the defense made in open court a constitutional objection. I am sure they have filed a motion. They must have, because I do it on my cases, that every single objection I make, I'm going to rely on it to what's called federalize it, to say that it's a violation of the Constitution, due process right through the 14th Amendment of a right to a fair trial, right to counsel, and all through the 5th and the 6th Amendments. Okay, so I'm sure the defense must be doing that, but I'm sure that indeed Bob Alessi is really upset. Welcome, Judy Cook, a new member. Thank you for coming. I have a lot of other things I have to show you. As you know, here comes drama. Gifted, while she's telling the jury about her 3 questions, let me tell you, gifted 1 Justice Served TV membership. Thank you. Here comes drama. Joey Kane gifted 1 Justice Served TV membership. Joanna Goddess, we already talked about, and we're going to show with the next break. Somebody else has ordered a hoodie. We're going to thank them and all. And Linda, can people demonstrate? Yes, they can demonstrate. I'll read to you exactly what the court said. We don't need to hear Bev on her 3 questions, right? Let me give you a fair trial. Did you listen to anything? Come on, give me a break, all right? But we'll read to you on hopefully the next break exactly what the court said you can do to protest the government here. You know, we'll see. I thought maybe we can put it up here. Maybe you know, I'll see what we can do because it's very specific and all. By the way, to making a count, thank you for your hoodie order. The Justice Served TV community is one of a kind. Michael, Linda, Mods, and Chad have come to feel like extended family. Keep fighting that good fight. And she ordered a number of things from one side, including this hoodie that Diz designed. Thank you so very much. We'll put that up after. Has Alessi gone up there to start yet? If not, the district court said you can advocate. You can't advocate outcomes.
Thank you. Good morning, Your Honor.
Let's see. I won't be able to read you the actual 2 paragraphs because I think Alessi is close to going on the stand. Mr. Welcher.
We're going to ask you to not turn on your computer yet.
Okey-dokey.
How about taking off your watch? Because you were looking at your Apple Watch yesterday too.
Text messages during his direct, if we can make sure that that does not occur.
I can get my email. I'll take all the time.
Okay, or just don't look at your watch.
Oh, well, look at that. I said it just before he said it, okay? We talked about it last night on our show. He was looking at his watch. Okay, let's go into court. Listen, I'll be behind the Tuvi avatar,
Do
but
you
I'm
know
here.
whether there was glass found on the bumper of Miss Reed's Lexus SUV?
My understanding there was, yes.
Did you reach a conclusion on whether the glass on the bumper came from the drinking glass that you assert Mr. O'Keefe was holding at the time of the alleged impact?
I didn't have an opportunity to inspect the glass, but the glass was broken and there was glass on the bumper. That's all I know.
So you, as you sit here today, you have no basis to conclude that the glass on the bumper came from the glass that you depict as having been held by Mr. O'Keefe at the time of the alleged impact. Is that correct?
Well, you're mixing a couple things.
No, Dr. Welcher,
So
if you can just answer my question.
I'm
If
trying
I
to.
need to rephrase it, I will. I'll ask it a different way.
Please.
You have no basis as you sit here today to conclude that the glass on the bumper came from a drinking glass connected to Mr. O'Keefe, do you?
Well, we have a picture of a broken glass at the scene. So I wouldn't say we have no basis. We don't necessarily have enough to conclude it's from it, though.
So the answer is no.
Do you had depictions in your test with Mr. O'Keefe holding a glass, correct?
Correct.
My question is, you have no evidence to show at all other than, and I'm talking evidence, testing information. You're saying you have no evidence that shows that the glass on the bumper is not the same glass as you showed on your slides as being found supposedly at the scene. You have no test evidence that that's the same glass, do you?
So again, the one I have at my testing obviously was not the same glass. We have pictures of a broken bar glass in the snow near where Mr. O'Keefe's body was. We have glass fragments on the rear of the bumper. That's the extent of my knowledge on the correlation between those two.
So do you said you reviewed the reports and testimonies of various Commonwealth representatives, correct? That's in your report.
Correct. In the initial,
right, correct. And some of those reports included forensic scientists who work for the Massachusetts State Police, correct?
I believe that's correct.
And you put those in your report as documents that you reviewed, correct?
Correct.
And as you sit here today, it's your testimony. You don't know whether in any of the reports of the Massachusetts State Police, there is an answer to the question of whether there's any connection at all between the glass found in the snow and the glass on the bumper.
I recall it being inconclusive.
Oh, so you recall that the testing was inconclusive?
I don't remember what testing they did, but for example, when they put the taillight fragments back together, they were able to deduce that the fragments were from the taillight. I don't think they attempted to do that with the glass.
Assume that there has been testing of the glass on the bumper, and assume that that testing conclusively determines that the glass on the bumper is not the glass that was found in the snow.
Okay.
Assume that.
Okay.
How would that affect your analysis?
I'd want to know where the glass came from, but we still have a whole bunch of other elements. So I don't think it would affect the end results.
So would it have any part in your analysis with my assumption that the glass on the bumper is not the glass that's associated with the broken glass that was supposedly found in the snow?
Yes. I mean, we always want to have as much answers or as many answers as possible. So I would want to know if we could figure out where it came from.
And wouldn't the fact, assuming that the test results show there's no connection, meaning the glass on the bumper is different from the glass in the snow, wouldn't that be contrary to your theory of what happened in some way?
It depends on when the glass was actually broken. The glass was in his hand, at least that's the testimonial evidence I have seen.
What?
So
If it didn't match,
it
now
whether it's broken from
What?
contact with the rear of the vehicle or broken with contact on the ground.
it's not the same glass, you idiot.
That the glass on the bumper is not the glass that was found in the snowbank. Doesn't that, at least in part, contradict your hypothesis as to whether there was contact by the Lexus with Mr. O'Keefe at 34 Fairview?
So if you recall all my slides, nowhere did we discuss that in my slides. So no, it wouldn't contradict it. I would want to know where that glass came from.
But you didn't seek that information, did you, sir, in your analysis to determine where the glass came from?
Well, of course I did. I read the reports about it.
But you sit here and you say you don't know the answer. There's steps you could have taken to get that answer quite easily. Couldn't you have, sir?
Not me. That's a material science expert.
You've been communicating with Lieutenant Tully, haven't you?
Correct.
You couldn't have asked Lieutenant Tully that question?
To my knowledge, he's not a material science expert.
But could he have told you the result of testing on that glass on the bumper and whether it was any way associated with the glass found in the snow? Wouldn't that have been an easy question to ask him? Just, has there been testing, and if so, what's the results?
Yes, but my knowledge from reading the reports was it was inconclusive.
But you didn't read all of the reports, did you, sir?
Apparently not.
Let's turn to another
Ooh,
topic.
I like that.
Laser
Apparently
scans.
not.
Part of your analysis involved conducting laser scans of portions of 1 Meadows Avenue, the house of Mr. O'Keefe, correct?
Correct.
Those laser scans were used, at least in part, to answer the question of whether the collision between Miss Reed's SUV and Mr. O'Keefe's Chevy Traverse at 1 Meadows at approximately 5:07 a.m. on January 29, 2022, caused the right rear taillight of the Lexus to break, correct?
Correct.
And in that analysis, inches literally matter, correct?
You want to get it as accurate as possible.
And the reason why inches matter is because, and we're going to get to this, you try, and you did it in your slide presentation on direct, you tried to see whether the Lexus lined up with the Traverse such that there could be a break of the taillight. That was part of your analysis, correct?
So the main part of the photogrammetry was to determine the speeds and the angles and the degree of overlap on the vehicles. And then we also looked at the damage from the video, or actually it's just where the snow was knocked off the rear of the Chevy Traverse, and document the height of that.
You said the main part. I don't want to engage in semantics. I want to go to my question of, isn't part of the laser scan analysis to determine whether or not those two vehicles align sufficiently such that the Lexus could break, the taillight of the Lexus could break coming into contact with the Chevy Traverse? Wasn't that part of your analysis, at least in part?
Yes.
Okay. And in that analysis, inches literally matter, correct?
It can, depending on which way you're going inches.
So the Ring camera at 1 Meadows, you're familiar with that Ring camera, right? At
Correct.
1 Meadows? That Ring camera at 1 Meadows was used as part of the laser scan process that you and your firm Aperture performed at 1 Meadows on October 2nd, 2024. Do I have the date correct?
I believe so, but like the videos were not literally used during the laser scans. We took the laser scans, the video, combined them together in a process called photogrammetry.
Okay, let's get this down to the fundamentals. You used, and that was my question, Your Honor, if we could publish the exhibit with regard to the Ring camera.
Sure. What exhibit is it?
Yeah, I've got my.
He doesn't want to answer the question.
Dr. Welcher, you recognize that Ring camera as being at 1 Meadows. You discussed it. As a matter of fact, I need direct testimony, correct?
Yes.
Now, that Ring camera was utilized as part of your laser scan process, correct? It was used.
So you're confusing laser scan and photogrammetry. The video, the laser scanners are together used in the photogrammetry.
Photogrammetry is a measurement. Is a measurement, everybody, just so you
with
know.
each other.
Was that Ring camera used for any part of your work?
Absolutely, the photogrammetry.
I just need to be able to finish my question, sir. Was that
Sorry.
Ring camera used for any part of your work at 1 Meadows on October 2nd, 2024?
Yes.
And it was used for what purpose?
In the photogrammetric process, to establish the position and dimensions of various things in the video. So then we could go back and overlay the vehicles and track the tracks in the snow as well as look at the damage to the vehicles.
Right. So this was used to, as a basis, not the only one, to establish dimensions. Other work that was done in analysis at One Meadows, correct?
Correct.
You can take that down, Mr. Wope. You know that the Ring camera at One Meadows, in existence when Aperture did the work on October 2nd, 2024, was different than the Ring camera that was in existence on January 29th of 2022, the date where you went through to see if those two vehicles align. Is that correct? The cameras are different.
That is correct.
And you know that the cameras are different, and you knew that as part of your analysis, correct?
Correct.
Did you document the differences between the two cameras as part of any work performed at One Meadows?
Yes.
And did you measure any differences there might have been between the location of the newer Ring camera from the older one that was in existence on January 29th of 2022?
No, what we did is use the current Ring camera in conjunction with the old Ring camera, and with the laser scans, we're able to, again, map the points onto the scene. That's why I showed you the report from the photogrammetry software that reported our error.
Sir, my question was just measurement, not your process.
Oh.
Did you measure the difference
I don't believe so.
between where the
Boom.
old camera was
Boom.
and where the new camera was?
No, it was angled slightly more to the right, though.
How would you know that if you were not retained on January 29th of 2022? How would you know where the original angles were?
Because when you look at the first camera, the one on January 22nd, it's here. The new one is slightly over to the right.
That's an eyeball approximation analysis. That's not a measurement, correct?
Well, I don't know that we actually measured it, but we accounted for it and corrected for it. But you can see, for
can't
example,
account and
what
correct it for it if you
the
don't know what the
original one
measurement
shows, for
difference is
example,
on
to the left-hand side
photogrammetry.
compared to what the new one shows to the left-hand side, and it's angled more to the right.
Sir, you have experience with Ring cameras, correct?
I do.
And I think a lot of members of the public have experience with Ring cameras. You can move just the camera portion ever so slightly and change significantly the angle of the camera, can't you, what it captures? Just a small turn,
Potentially.
right? Even a millimeter turn can make a change. A 2 millimeter, a 1 inch can make a significant change with regard to what the camera captures, correct?
Could, sure.
So, did you measure whether the newer camera that was present on October 2nd, 2024 was installed to the left? And I'm talking measure to the right, to the top, or the bottom relative to the camera that was there on January 29th of 2022.
So, we
So,
solved for the camera
I'm
position.
asking if you measured, sir.
Oh, no, we didn't measure.
So
that's the answer. Didn't measure.
let's talk about,
Ladies and gentlemen,
some other
garbage in,
differences
garbage out.
with regard to cameras and Ring cameras. Different Ring cameras can have different levels of distortion, correct?
Potentially.
Cameras, well, are you saying that all Ring cameras have the same level of distortion?
No, but again, they're mass produced. So you could have some that have the same exact distortion. You could have some that have different.
And you don't know the comparative distortion between what I'm just going to now refer to as the old Ring camera that was there January 29, 2022, and the camera that you saw on October 2024, which I'll refer to the new camera. You don't know the difference in the distortion between those cameras as you sit here today, do you?
So we know enough information that if the distortions had been different, our errors would have been too high. And so the fact that our errors
Oh,
are within
bullshit. I'm
acceptable,
sorry. That's a
it's
legal
called an
term.
RMS error, we know that the distortions are similar enough to give us accurate measurements.
Sir, that is speculation.
It
That
is
is
not.
not data. That is not a measurement. You didn't measure the distortion, sir, did you? If the cameras, you didn't have the old camera to do it.
We didn't, but we had images from the old camera. And then when we get images from the new camera and solve those camera properties and then overlay data from the old images to the new images with the point clouds, if that distortion is too great, we will have too high of errors in our project, which is why I showed the error report from the photogrammetry process to show that we have checked for that and documented that our errors are an acceptable range so that we have confidence in our results.
You do not have information from the manufacturer of Ring. You didn't
He
present
can't have
it, and
confidence
you
in
don't
his
have it
results
as
because
to what
this is
the
not
acceptable
a
level of
peer-reviewed
analysis
expert
that you did.
analysis.
The
You have
photogrammetry,
that from Ring.
and I don't have it for Ring, but I
Thank
don't need
you.
it from Ring.
So now let's go to, if cameras have different levels of distortion, that would change the analysis in reconciling the difference between their angles. That's a pretty straightforward proposition, sir. Wouldn't it?
So it depends on how much difference it is, but we have accounted for that.
No, you
With-
haven't because you didn't
Which
measure.
model of the Ring camera was present at One Meadows on January 29th, 2022? Which model?
I don't know. I'd have to go look through the data.
Do you believe I'm not going to take up the time to have you look, but do you really believe you've got the model of the Ring camera that was in existence on January 29th of 2022?
I don't know. I
You
need to
didn't
look through the
present it
report.
in your direct testimony, did you, sir?
I did not.
So do you have the model of the Ring camera that was present at One Meadows on October 2nd, 2024?
No.
So you
Wait,
don't have the
no
model for either one of
models?
them.
Nope. But we have videos from both of them and scans of the scene.
So now let's
Oh my
talk about
gosh.
another aspect of Ring cameras. They have mechanisms, as I was talking about earlier, that allow the user to adjust the camera angle, correct?
Correct.
And do you know whether there was a difference in the camera angle between the two cameras?
Yes, as we already discussed, there was a slight difference in the
But
angles.
you don't have a measurement of that, right, sir?
Correct.
Okay.
But
This is
we
very important
accounted
because
for it.
photogrammetry is all about measurements, precise measurements, okay?
Wouldn't a difference in models of Ring cameras be relevant at all to your analysis of trying to reconcile?
Don't
any
ask him
differences
unless you
between them?
tell him.
So if you have video from both of them and you have laser scans with three-dimensional
You're
geometry
taking
of
it
the
off. You're
scene,
taking it off
you
the
can
fact
go
that
in
you
and
don't
it's-
know what
it's called
the
a
measurements
reverse
are to
camera
begin
analysis.
with.
and solve for the distortion properties. The scans give you the real world dimensions. So once you know the real world dimensions, you can then go in, man, you can go in and then solve for the camera lens properties based upon the real world distortions. So for example, if there's a little bit of bending at the end, the laser scan data will show that, and you can correct for that knowing information about the laser scanner.
I'll
or
ask
the
the
laser
question.
scan data.
I'm sorry, I thought you finished, sir. I'm going to ask the question again because it's a narrow question. Wouldn't knowing the difference in the models be relevant? That's all I'm asking. Wouldn't it be relevant to your analysis of reconciling the differences to them? Wouldn't
No.
it be relevant?
No.
So you think the different models are irrelevant to any process you occasioned at one? It's irrelevant.
So the analysis of the video itself is more important than the models?
I'm not asking if it's more important. I'm just asking, would it be relevant?
No, I don't believe it'd be relevant.
Now let's go to another aspect of the cameras. Are key parameters in a camera that the software needs to know focal length?
It is.
Is imaging size something that is an important parameter in a camera?
Yes.
Is our sampling characteristics an important parameter in cameras?
Can be.
Is the principal point, you understand that concept, sir? Is that an important parameter in a camera?
Define how you're using principal point.
Sure. A principal point of an image is the point where a camera's direct line of sight, called, as you may know, the optical axis, intersects the image plane. Does that
Gotcha,
sound
yes.
familiar?
Mhm.
So isn't that the image's mathematical center, the principal point?
More or less, yes.
And for high accuracy photogrammetric work, it's important to know if the lens is mounted centered over the image sensor due to the small manufacturing variances, correct?
Could be important.
And if the principal point is the center of the image. That's relevant. So doesn't that affect the mathematical calculation of the light ray geometry?
It could.
So the variance in manufacturing between cameras is a known issue. Do you agree?
I do.
There's small manufacturing variances that affect one of the key components of the fundamental parameters of the camera, namely the principal point, right?
Correct.
Did you perform the camera calibration of the camera in place in October of 2024?
Yes. So within photogrammetry, we
Just answer
calibrated
yes or no.
photogrammetric analysis to the camera.
Did you address the principal point in that calibration? Do you have documentation that you addressed that important factor, the principal point?
So the
The answer is no. When you
checking
saw
of the RMS error in the software takes into account, sums up all the potential errors in the measurement, which would include that.
Sir, you know the importance of all of these topics because the output of all the work Aperture did at One Meadows, almost all of it springs from that camera, correct?
It starts there.
Okay, it starts there. And if the starting point is wrong, then where you go from the starting point is going to be at least potentially wrong, correct?
Potentially.
Would you agree that Ring cameras have a swiveling mechanism so that the user can adjust the camera angle?
Some do.
Do you know whether the camera that was in existence on January 29, 2022 had a swiveling mechanism?
I believe it did.
Believe? Do you know?
I do not know for a fact, but
you-
those style of Ring cameras on the surveillance have adjustability that includes angle.
But you don't know whether the camera that was there, the specific camera on January 29, 2022, had a swiveling mechanism or not, correct?
Correct.
And do you know whether the camera that you saw in October of 2024 had a swiveling mechanism on it?
It did.
And where did you document the fact that it had a swiveling mechanism?
I think we have photos of the camera.
Did you document it in writing, and did you document the tolerance of the swiveling mechanism?
No.
Let's go to, and again, all of the camera, this camera that you use is the starting point for your laser scan and photogrammetry process, correct?
Correct.
All right. Let's go to another topic. On your direct testimony, as I recall, you stated essentially from various information that you lined up in the video, and we're talking about the lining up of the Lexus with the Traverse. And this is at One Meadows. And so, as I understand what you did, sir, is you took what are called point clouds, 3D images, created them for the Lexus. You took created 3D images, synonym point clouds of the Traverse, and then you attempted to line them up to determine, among other things, whether they would align sufficient so that the Lexus could line up and potentially hit the Traverse such that the tail light of the Lexus could be broken. Was that at least part of your analysis?
That was part. There was more.
So you showed a slide, a few slides, and with your Honor's permission, what I'd like to do is to start with slide 90.
All right. Do you have any problem with Dr. Welcher keeping his printed copy that he was using?
I have no problem with the printed copy, Your Honor.
I love the fact that we began though today with what we
90.
talked about, that because he was looking at his watch the whole time, and he says, "Well," he says to the judge, "Well, I use my watch to get my email." Precisely. Now he can't do it.
Yes, yeah.
And this is a very good cross-examination by Alessi. I think he's rebounded. Yesterday, he tried to keep track with him.
Does
Today,
that
he
slide,
is really
as part of
on
your
point.
presentation, depict a view from the top of the Lexus on the right and the Chevy Traverse on the left.
Correct.
And is that depicting contact between the two vehicles?
It is.
Now let's zero in a closer look, and that is a contact point. Am I correct?
Correct. I mean, there's multiple points. There's
Multiple
more than one.
points, but it shows more clearly the contact
Correct.
between the two vehicles. Now, if we could the next, and that is number 91, Mr. Wolf. So, Your Honor, 91. I think these are just going to go in order for a few, and I'll keep announcing them. So, this is 91, same vehicles, just a different viewpoint. Is that correct, Dr. Welcher?
Correct. This and the next
I
slide.
just want to stay
I know.
with this one. I
Hold
just
on a
asked the
second.
question, does it show the contact?
So go ahead and answer now.
This slide and all the other slides, we're trying to show the angle of contact, but because it's two-dimensional image, you're losing some perspective. For example, here you're seeing the chrome piece on Mr. O'Keefe's Chevrolet, which is on the right. You're seeing it obviously behind where the Lexus is. So we were trying to show it at a whole bunch of different angles to try and illustrate the degree of closeness or lack thereof.
All righty. So
Thank you.
is it correct that on your direct examination, you said in sum and substance, we looked at the degree of overlap and there's only about a 2 to 3 millimeters of overlap between the vehicles? Is that what you recall saying on direct?
That is correct.
And that you stated that supposed 2 to 3 millimeters of overlap was insufficient to cause the tail light of the Lexus to contact the rear of the Chevrolet. You recall saying that?
That's correct.
Now, I would like you to look at that. This is from your slide presentation. Is that not showing contact between the two vehicles?
Oh, it absolutely is not. What you're seeing is a portion of the vehicle that is behind the area. Keep in mind the angle, the Lexus is angled off to the left.
We all
So the
saw the
area that you
contact
see
because
here
we
is
saw the
actually,
car move.
In this case, in front of where the taillight is. This is why we tried showing it from a whole bunch of different angles, because when you try and take a two-dimensional image and look at it, you see stuff in the background. So and again, this is why in the computer, we overlaid them, looked at the measurements, in the computer where you don't have this, we have the three-dimensional measurements and it does not hit.
Where did you show in your slide presentation what you just said, that it doesn't show an overlap?
So
Where?
it shows a contact. It definitely contacted, I'm sorry, Mr. Reporter, down below here. It does not show a contact here. So to answer your question, all the next slides were our attempt to do that. So all the next slides is your answer.
We're going to go to those next slides. So just to be clear, you're saying that depiction does not show any contact between the taillight of the Lexus and the Chevy Traverse.
So the upper taillight, just to be clear, because the lower taillight is much closer.
Well, it's not only much closer, it's in contact, isn't it, sir?
It's very close. It's probably within an inch being in contact.
Oh, so you state that even the lower part of the taillight is not making contact?
So if, again, maybe there's a photo we could show or a scan that is on the rear of the vehicle and it contacts on the corner, which is just around. So maybe like an inch or so in front of it on the corner.
I'm just going with what you presented in your slide
Well, let's
presentation.
go to the next slides and then
Sir,
maybe
I
we'll see.
will determine which slides we go to on my question.
I'm just hoping
So
to
now
answer your
let's
question.
go to Mr.
What an
Wolf's
asshole.
next
Excuse me.
slide.
There we go.
In your presentation, my question is zeroing in. Are you saying that that slide does not show contact between the tail light of Ms. Reed's Lexus and any part of the Chevy Traverse?
Yeah, absolutely. It's exactly what it shows. You can see a little better here. Again, we tried all these different angles, which is why all these slides are in there. But you can see some of the geometry of the light. This structure, and again, remember I said the Chevy kind of curves in as it goes up a little bit.
Let's go to the next slide.
And remember, this is a 2D depiction, okay? Interesting. They didn't take a 3D depiction.
Is it working? 41, Your Honor.
That's exhibit 41? No, as a question, because that's not my slide.
Hank Liars for hire. I'm sure the
So,
defense
Mr.
has
Alessi,
everything
is
I
this
have.
exhibit number 41, or is this from the PowerPoint? Because,
Slide 41. Slide.
okay.
Because what? What are you worrying about, Judge Kenney? Let him do his cross-examination. He's making it very clear where this is from.
So I'm putting this up because I want to show an actual photograph of that tail light. And I would like you, sir, to focus on the quarter panel tail light in each. Do you see a jutting out of the quarter panel tail light in that photo? You see it jut out?
So I don't know if you and I are talking the same thing. There are little fins here.
Correct. Now, what I'd like to do is to go back to the depiction we were just looking at. And that depiction doesn't show the jutting out, does it?
No, it does. Those are actually more on the side of the vehicle. You can't see them in this image.
Correct. You
But-
can't see them.
Hold on
Can't
a second. I
see
wasn't
the
finished.
fins in the
They
image.
they are 100% there. We actually did special hand scans with a hand scanner of the taillight to put it back on to the vehicle.
You say they're 100% there, but you can't see it in that depiction, can you?
Boom.
The jutting out that you could see in the two-dimensional one we just saw. You can't see it.
I can't see who's behind that wall because it's being blocked by something. I can't see behind.
It's
on the
your
side of
it's
the
your
taillight
slide.
because it's on
I'm
the
going
side I can't
crazy
see.
here.
It's being
It's
blocked.
your slide,
My
asshole.
question is simple. You cannot see the jutting out of the tail light in this depiction, can you?
Correct.
Okay, now let's go on to the next question in this topic. You could have easily solved what you consider to be the issues you had with trying to show it lining up, couldn't you, sir? You had an easy solution for that.
I took the best solution. I'm not sure what
You
you're referring
had
to.
3D images, correct?
I did.
You
Stay with
could
us.
have
Okay? I told you about 3D
shown
images.
and measured 3D images to get almost the exact contact point and almost the exact dimensions if you had just used the 3D images that you had available to you. Isn't that correct?
That's exactly what we did. When I went through the video analysis, I showed you how we overlaid the point clouds, the 3D scans on top of each vehicle. So we took the, I'm sorry, we took
Sir,
the
please
vehicles.
don't interrupt.
Hold on.
Objection.
Your
Hold
Honor,
on.
he keeps referencing my hand and saying I'm doing something when I'm not. And I think that's distracting to the jury.
So-
I'm not interrupting
Hold
him.
on. Let the witness answer the
I
question.
am. I'm just holding my hand like this, Your Honor. He keeps saying that I'm doing
Mr.
something.
Leslie, please.
All right.
Go ahead, finish the answer, Dr. Welcher.
Again, in the photogrammetric analysis, I showed the video. I showed how we overlaid the point cloud on top of the video. That proves that the way we solved it, correct camera characteristics, matches. Otherwise, that would be distorted. We overlaid the scans of the Lexus into the photogrammetric analysis. We overlaid the scans of the scene into the photogrammetric analysis. We overlaid all that stuff into the analysis. We did exactly what you're suggesting.
You could have easily addressed this issue by the following. If you really believe there was no contact or not sufficient contact, you could have produced a graphic that shows a gap between the two vehicles. A graphic, couldn't you? That's not a graphic.
What is that?
Sir,
Here, let me get my Merriam-Webster
ask
dictionary.
questions, and you are to answer them subject to the judge's ruling. So my question is, couldn't you have created a graphic that
That's-
would have better shown the issue that you are creating or talking about today? That's my question. Couldn't you have created a graphic?
We did. We created a whole bunch of graphics.
You called what we just saw a graphic?
Yes.
Well, if there's a gap, why isn't there then something that shows a clear gap?
Because when you have the angulation of the vehicles, you have perspective. When you're looking at it, even if you do a top down, you see everything projected onto a single flat plane. So you can't tell the height of things. So when you see things in this dimension, you can't necessarily see depth of things. So you lose in two-dimensional images, you lose one dimension
Precisely.
depending
So
on
you
which way you're
didn't
looking.
see the impact
I
because the
showed from all
fins
these
aren't
different
showing in a
angles
two-dimensional
to try to show
image.
exactly what you're saying. We had graphics to do that.
3D images allow you to show perspectives for 360 degrees, correct?
Oh, taking
Is
the
that
water, thirsty,
So
mouth dry, nervous.
none of what you presented in your slideshow shows the contact points from 360 degrees.
Your answer's not in there, sir.
I don't understand your question. Are you asking if I showed it at every single, I went through 360 slides that showed it at every single degree?
Sir, let's move on. I think I've made the point.
You didn't.
So I'm going to strike the comment,
Okay.
Mr. Leslie.
Dr. Welcher, let's go to the next topic. And keep with these two depictions. Are these two images point clouds or 3D images? Are these two?
Those are one and the same thing. They're yes.
I would use them as synonym. Which term of the two do you want to use? Point cloud or 3D images?
Both are fine. It's a 3D image composed of points, whichever.
Okay, so let's just call them 3D images so we
Okay.
can do this more quickly. The Lexus and the Chevy Traverse that are depicted there are both 3D images of those vehicles, correct?
Correct.
And Aperture created the 3D images, correct?
Correct.
Sir, did you do these scans and did you personally create these images?
No, one of the assistants at Aperture did.
So you're speaking about what somebody else did at Aperture, correct?
They were doing it at my direction. And for example, the Lexus scan, I showed the photographs. You can see the gentleman that works at Aperture, Mike Morelli, was scanning them for me while I was doing the rest of the inspection. And then the hand scanning of the rear tail light was done by another engineer. I was out there with him doing it, taking measurements. And then same thing with the Chevy Traverse.
My question is, you didn't do the creation of these 3D images, did you?
The individual images, no.
All right, so let's go to these individual images. These are 3D images. Is that your testimony?
Yes.
Let's look at the taillight.
Okay.
That's not a 3D image. That's a Photoshop, isn't it?
Nope.
Oh, so it's your testimony that that taillight is a 3D image.
That absolutely is a 3D image. The way you can tell is when you get up near the chrome, because lasers don't like shiny objects, you start to get a scatter. So see all these dots here? If that was a photo, you wouldn't have these dots.
Let's go to the Chevy Traverse. Let's, Mr. Woke, zero in on the content. Yeah. There's grain on that taillight, in the taillight. That's a 3D image of a taillight, isn't it, sir?
They're both 3D images.
Well, I just want to stay with one. That taillight is a 3D image, and one of the ways you can tell is it's because it's got all that grainy material on it, correct?
Correct.
Now let's go back, Mr. Woke, to the Lexus. Let's now go to the bumper.
But do you want me to explain the difference?
No,
Okay.
thank you. I would like to go to the bumper. Do you see any the predominance of any grainy image on the bumper?
There's a little bit. So for example, when you get near edges, it has a hard time with edges.
I'm sorry, the bumper cover.
Right.
See the bumper cover up above?
This whole thing is the bumper cover. That's the step pad. That's the rear body panel or the rear deck lid.
I'm talking about the step pad, sir. Just the step pad of the bumper?
Are you asking about just from here to here?
Correct. The bumper step
Can we
pad.
zoom in on it?
Pardon me?
Can we zoom in on it?
Sure. Do you see any?
Yeah, I see graininess.
Let's go over to.
Right in here. You can see it all through here. You see it through here.
Well, I'm talking about the step pad, not the entire bumper. I'm just talking about the step pad.
Right. So you're zooming in on the bumper.
Right.
The step pad is this structure up here.
We're going to move up. It just takes a while. So your testimony is that is a.
Can you zoom in more?
That's you would like it zoomed in?
Yes, sir.
Sure. Your testimony is that is a 3D image, not a Photoshop step bumper cover. Is that correct?
So we have mapped the color over the 3D scans. We used two separate scanners. If you recall, when I got out to Miss Reed's vehicle, that taillight was gone. So we had to replace the taillight.
Talking about the bumper cover, not the taillight.
Okay, I'm explaining the process.
I just asking about the bumper cover, not the process.
So focus your answer on the bumper.
That is a laser scan.
Okay, so your
That's a 3D
testimony
model.
is the step
Finally,
pad
Judge
bumper
Kenney,
cover
tell him to answer the
is
question.
a 3D image from a laser scan, and it's not a Photoshop. That's your testimony.
Absolutely.
And you didn't perform the work for the 3D that you claim the bumper step up is. You didn't do that work to produce that depiction, did you, sir? Somebody else in your firm did it.
So this is all done at my direction. The engineers that work for me, so I'm telling them what to do. I'm not the one punching the keys.
That's
I'm
my
saying,
question.
I need you to do this, and this. Use the hand scanner, go scan the light. I need to put this back in because it was missing when we got to it. So no, I'm not punching the keys.
Okay, so
Okay. Come on over, please.
Okay, we seem to have a significant area. It tells me that answering these questions about the Photoshop, because he didn't do the work, that there is some expert that has been advising them that this is a Photoshop and not a 3D scan that we're seeing, or maybe it's a Photoshop with a 3D scan or whatever. But Alessi, he is extremely precise, and he would not be asking these questions without that information. And it turns out that this witness did not supervise or do these slides, right? It turns out that's the case. But forget that for the moment. I think it was a boom point that the Lexus has the fins on the side of the light. Now, remember, it's those fins that this expert said caused the damage on John O'Keefe. But then when the fins would show that the light, the upper tail light, hit the traverse, John O'Keefe's traverse in the driveway at 5 o'clock or around 5 o'clock in the morning, all of a sudden the fins disappear. They're now around the corner because it's a 2D photograph, and the 2D photograph didn't show you the 3D around the corner. And also their angulation didn't show that. So far, I think this cross-examination has been an absolute home run for Alessi. He has got Welcher on the run, and the judge can't do anything about it right now. As a matter of fact, she told him to answer the question.
With regard to, no, we don't need to back up, Mr. Wolf. Isn't it correct that 3D images allow for proper and most accurate measurements as opposed to 2D images? Is that a correct general statement?
I mean, generally, yeah.
Okay, that's my question. So let's go to the next topic. Let's talk about hydraulics on the Lexus SUV. What type of hydraulic system does the Lexus SUV have?
So it has a mechanism, I believe it's actually pneumatic. It's air-based system that raises it up and down.
Do you know what the name of that system is, sir?
No, not off the top of my head.
Do you know how it works specifically?
I do. Well, I mean, I know generally that there's a button on the interior where you can raise and lower the ride height.
And is that the extent of your knowledge of that system on the Lexus?
No. Again, I know when you park it, it'll drop down the ride height. When you adjust it for different roadway conditions, it'll change the ride height.
Do you know what the height tolerances are? In other words, the lowest to the highest?
I believe it's around 1.25 inches. At one point in time, I measured it. I don't remember off the top of my head.
So you believe it's 1.25 inches up and 1.25 inches down? How do you apply the 1.25 inches?
I recall the total being like 1.25 inches, but I measured it at one point in time. I just don't remember off the top of my head.
Would you be surprised to hear that the tolerance is 5 inches on that vehicle?
I would be surprised. I don't recall it being that much, but I would need to double check.
Assume that the manual, as well as other informations, support that the tolerance is 5 inches and that specifically the vehicle can be raised 3 inches high and it can be lowered 2 inches. That's the basis for the 5. What was the suspension height of Miss Reed's Lexus that you used for your accident reconstruction analysis out front at 34 Fairview between 12 a.m. and 1 a.m. on January 29, 2022 to determine whether it was possible for the spoiler on the back of the Lexus to make contact with the eye of Mr. O'Keefe? If it was even possible, what did you use for a measurement of the suspension?
Matched the measurements from when the vehicle was tested, I believe on February 1st at the Canton Police Department.
What match did you make?
So we aligned the bottom of the taillight, actually the sheet metal right below the taillight. So we adjusted the height of the Lexus to match that.
Did you in any place document what level the Lexus was at the time of any testing, meaning the suspension? Did you document at all?
Yes.
Where?
Slide 107.
Can we have slide 107, Mr. Wolf?
And then if you could zoom in on the lower photograph, the gentleman with the blue shirt. Zoom in a little more, please. So if I may, we matched the bottom of the sheet metal here to photographs when it was at the Canton Police Department.
Sir, my question is, where did you document whether the suspension was at 0, whether it was +3 or -2? Where did you document that?
Right here.
And what are the numbers of the documentation of that?
I don't know. We were matching the photos. So I don't care what the numbers are. I care that the height is the same.
Okay, so I just heard you say, if I heard correctly, you don't care what the suspension is at. Is that your testimony?
No, I don't care what the suspension number is as long as the heights match.
I understand. I understand. So what was the suspension height of Miss Reed's Lexus at 5:07 a.m. on January 29th, 2022, while at One Meadows and colliding with the Chevy Traverse? What was the suspension height then?
We assumed it was the same as when it was at the Canton Police Department.
Exactly. You assumed, but there's no measurement like was just on that depiction. There was no note that said, okay, we're doing this very important and inches sensitive measurements to see whether the tail light on the Lexus makes contact with the Traverse, but there's no measurement and no documentation of what the suspension height was at One Meadows, correct?
So we took the closest measurement in time to the One Meadows event, which is when it was at the Canton Police Department. That was the best information we had.
Well, that information isn't very good because the vehicle had to go from Canton to One Meadows. And when the vehicle drives, the way the suspension system works, it's automatic. When you go above 20 miles an hour, the suspension comes up. And when you turn off the vehicle, it goes down so you can get out easier. So it would be improper to assume that the suspension at One Meadows would be the same at another location.
That's the only, sorry.
Was there an objection? No. Go ahead and answer, please.
That's the extent of the information we had. We had it when it was at the Canton Police Department.
That's-
We matched that height.
Sorry, sir. I understand.
But actually, you brought up a good point. It's going so slow when it's backing up that it wouldn't raise up. So the static position when it's backing up would be the static position.
But it wouldn't be going in backup from the Canton Police Department to One Meadows. It wouldn't be going back up when it's going in other locations, sir, right? It would be driving forward. It had to get from point A to point B.
Right, but as you pointed out, when you turn it off, it drops down, and then you turn it on, and then once you go above 20, as you indicated, it goes up. But when she's backing up, she never goes more than a couple miles an hour. So it's going to be at the same position as when you start, which is approximately the same position when it's off at the Canton Police Department a couple days later.
Do you know whether the suspension system locks when there is testing of the infotainment system?
Whether the suspensions, I don't know.
Okay, let's go on to the next topic. You're aware of the vehicle control, excuse me, Your Honor. Thank you, Your Honor. I want to go, I'm changing topics to go back now to Fairview, 34 Fairview. You don't know what the suspension ride height at 34 Fairview was on January 29th of 2022, do you?
Correct.
So therefore, if you don't know what the suspension height was, because of course you weren't there on January 29, 2022. Therefore there's no measuring stick, as you say, you assert that you would have accounted for it in your methodology. So you don't have the suspension height for that key day, do you, sir?
I only have it 2 days later.
All right. So when you talk about key measurements, such as the spoiler on the top of the Lexus and the inches that are important as to whether things such as, is there a contact with the front eye, you don't have some data that would be relevant to that calculation, the sum data being the suspension height of the Lexus at that time, do you?
So we have some data. We have photos of the vehicle 2 days later. We don't know the exact height outside because, as you alluded to, we don't have a measurement on January 29th of it, but we do have it 2 days later. That's the source of the measurement.
You don't have the suspension height or the setting of the suspension of the Lexus that existed on January 29th, 2022, do you?
Correct.
Now let's go on to another topic. Within the 34 Fairview on January 29th of 2022, I'm not going to go over them, but you asserted various measurements, height, width, with regard to the Lexus, correct? It wasn't just for the spoiler at the top, correct?
Correct.
And for all those other measurements that you talked about, you did not have the suspension height and the suspension setting of the hydraulic system of the Lexus on January 29th, 2022, did you?
So the hydraulic's only going to affect the vertical dimensions. It doesn't change anything left to right. It doesn't change anything down the side of the car.
Understood. But for the measurements that are affected by vertical, you didn't have the suspension height of the Lexus system on January 29th, 2022.
Again, I only know what it is 2 days later.
So now let's go on to vehicle control history. Sir, you understand what I mean by vehicle control history of the
This is text stream information.
Are you aware of what is called the Bosch crash data retrieval system in Lexus vehicles?
Of course, we showed it on my slides.
And the Bosch crash data retrieval system in Lexus vehicles is sometimes referred to as the black box.
No, you're mixing up two things. So the Bosch is like the tools.
It's a question, sir.
So you answer that with a yes or no?
Is the Bosch crash data retrieval system the black box on Lexus vehicles? I just wanted to repeat it so we can.
I didn't hear what the objection. You objected?
I'd like him to be able to finish his answers.
Yeah. So the question was just asked. Can you answer that question?
No, it doesn't make sense.
Okay, next question, Mr. Winston.
I'm going to ask the question, sir. The Bosch crash data retrieval system in Lexus vehicles, you're familiar with that? Are you familiar?
Oh, we just froze on our stream, and we published, actually, I'll have to find, I put it on our X account, somebody who did a report on this, that they're confusing apples and oranges because of the Lexus dealing with the Bosch elements, right? So let me see if I can find where well, we're still frozen here last night.
Diagnostic tool for their
Here we go.
Lexus technicians to assist in vehicle repair and maintenance. Is that what that is created for?
That's their stated
In maintenance. Is that what that is created for?
That's their stated purpose.
Right. And is a synonym for VCH text stream? Is
Sort of. Text stream, similar, like Bosch is the hardware and software to access the black box data. TechStream is the software to access, for example, the pre-collision system, the PCS system, and the VCH, which is the vehicle control history. So TechStream is, which does a lot of other stuff, but does access that information.
You just mentioned Bosch, didn't you, sir?
So Bosch is not in the Lexus. You use Bosch stuff sold by Bosch, Bosch software and hardware, and you walk up to the Lexus with all the Bosch stuff and plug it in and download the event data recorder, the EDR, the black box. That was my problem. There is no
Understood.
Bosch stuff in the Lexus.
I understand, sir. That was going to be the question that I was trying to get to, but you've explained it, so I don't have to answer the question. Let's go to the VCH database that you say the stated purpose is to assist technicians at Lexus in vehicle repair and maintenance.
So I didn't say that was a stated purpose. I'm saying that's what Lexus or Toyota says is a stated purpose. It's being used in litigation all the time. All I know is that's what Lexus and Toyota says. But again, it came about right when we started seeing all the sudden accelerations in the Toyota vehicles.
So my question is the VCH database specific to Toyota and Lexus vehicles?
So it's not a database, it's software.
Is the software specific to Lexus and Toyota? The VCH?
Those particular acronyms are, yes.
Want to move to another topic, and we are almost finished. We have just two more topics, sir. How common were VCH events when Miss Reed owned the Lexus?
In 2022,
Do you know the ownership period of Miss Reed with respect to the Lexus? You know how long she owned it?
I have that documentation. I don't know off the top of my head.
Do you have an approximate?
No, I mean, it was a 2021 vehicle. Our accident's January 29, 2022. But I did get that information.
Do you know how many VCH events were associated with the Lexus of Miss Reed?
I did not count them, no. I have them all.
Do you
I was
have-
only focused on the ones around our time period.
Exactly. But do you have the number of events? Do you know how many there were?
I could get it for you.
How long would it take, sir?
3 minutes?
Why don't we come back to it
Okay.
and we'll see if it's.
How about I start this so that we don't have to wait for it to boot up? And then when we come back to it, it's ready to go. You
As
okay with
long
that?
as that's all you're looking at, sir.
Yep.
Thank you. And then pick your head up, please, so I can finish these two
Please,
topics.
go ahead.
So how often were VCH events recorded on the Lexus before January 29th of 2022?
Man, I have to pull this data up.
Fair
to
enough, fair enough.
answer that
I
question.
assume that's going to be in what you're also pulling up.
That's the goal here.
Would the number be about 15? Does that sound right to you?
Let's see. 1, 2. There's 18.
18. So there were your records show that there were 18 VCH events recorded on Miss Reed's Lexus, correct?
Before the subject one.
Right. Did you conclude that any of those events, other than the 1162-2, were a collision?
No.
Now let's go to reverse recorded events. Can you tell how many of those 18 events were reverse recorded events? And you know what I mean by reverse recorded events? The
Yes.
vehicle going in reverse. How many of those events were the vehicle going in reverse?
And this is before.
4. Other than the,
He asked
No,
you,
I said
is this before?
yes, I'm sorry.
Oh, I would have to pull up the PCS file.
Could you start that and I can continue on with the questioning?
I got to, so the PCS file is I have a second laptop that
Here's
has
what I'm going to
texturing.
do. That's not important for me to keep going and get through it.
Okay.
So let's just stay on the events, okay? Only one of all of those events, those 18, are you concluding that there was a collision associated with them, correct? Just one.
No, all those 18 are before. The collision's number 19.
No, I'm saying, I understand what you're saying, but for all the other events that are recorded, you're not, other than the January 29, 11/62/2, you're not concluding that any of those were collisions, correct?
I didn't look at them. They were so far mileage away from everything.
But you're not concluding, even though they were so far away and you didn't look at them, you don't conclude from the information you have that any of them were a collision, correct? Let's go to 5:07 a.m. on January 29th, 2022 at 1 Meadows, the home of Mr. O'Keefe.
Okay.
There was a collision between Miss Reed's 6,000-pound Lexus and Mr. O'Keefe's approximately 4,500 Chevy Traverse. That's undisputed, correct? They collided. They made contact.
They touched.
Right. But the actual collision at 1 Meadows did not register
Touched.
the recording of an event on the Lexus VCH system, did it?
Correct. It's too minor.
So, however, you want this jury, sir, to conclude that the glancing blow that you contend occurred at 34 Fairview Road by the same 6,000-pound Lexus in contact with a mere 216-pound man did register an event on the Lexus, correct?
No, the impact didn't register the event. As I pointed out, the trigger was from when the accelerator pedal went to 30%. The tech stream does not register crashes at all. It registers excessive acceleration, excessive steering, excessive braking, things like that, things that would be part of the maintenance system. So the tech stream will never register an event, even if you hit a wall at 100 miles an hour necessarily. It'll cause fault codes and things like that. But that's not what it does. The trigger here was transitioning into reverse and then gunning the accelerator pedal in reverse. And so when it went from 30 up to 74% throttle, once it went over 30 in that transition, that's what triggered the tech stream. It had nothing to do with, and that's why I'm telling you, I don't know when in that event the impact occurred, because the tech stream doesn't tell you that.
Thank you. That
You're
is
welcome.
exactly my point. The tech stream information doesn't tell you when a collision occurs, does it?
Correct.
That's all the questions I have at this time, Your Honor.
All right, why don't we take our morning recess, James?
Okay, I think that Alessi, it was on point today. In terms of obviously the limitations that Judge Beverly Cannoni gave him. Let me just recap where we are from when we started this morning, and I'll get to a lot of your questions because they're fast and furious. We started this morning with my rant, which will be up soon, about Mr. Welcher, who apparently, knows the expert we're going to have tonight on at 6 p.m. on Justice Serve TV, Stephen Plord. He was on last week. Apparently just generally nice guy, but not here. Here he is a proverbial, excuse my language, asshole, all right? And I say that because I started the day with the rant. about his use of discussion and talking about Dr. Scordi-Bella, that he wouldn't consult a person like that, okay? I'm not going to go through the rant again, but I will say that the whole Commonwealth case, given the fact they seem to want to discount their female forensic neuropathologists, their female forensic pathologists, I really, to me, shows a little bit of rank, shall we say, sexism. And I don't say that lightly, because you know me, that I've been trying a lot of cases all over the United States. I don't usually say that lightly. But this whole attitude that we had about who we're going to consult, and this whole attitude about Karen Reed, I think it was more of an attitude. When an expert gets on the stand, they have to be likable, all right? You know that. I mean, when they get on the stand, they have to be, and we've seen likable experts. So we all the time we follow trials here. We see likable experts. We see likable attorneys. Now, where did Leslie go after that? Leslie then wanted, and I told you yesterday, Judge Beverly Kenney was not going to allow this. He wanted to question the doctor, Dr. Welcher. He wanted to question, I'm calling him Welcher. He wanted to question Welcher about the fact that Welcher had used the drone exhibit that all came from Trooper Paul's reports, not the CERT team, as he said yesterday. And they went there to show that was wrong, and all to Judge Kenney, and that the whole reason that he used that was because of the odometer mileage, and that was a starting point. And he wanted to question him about that use. He also wanted to question him about the cherry picking, and boy, cherry picking is even too little a word, about his, shall we say, use of documentation that only supported him and didn't support anything else. Dr. Scordi-Bella's two findings about the skull fracture and hypothermia, but he didn't want to go into all the rest of her findings. He wanted to go into the rest of her finding that she didn't declare this a homicide under extreme pressure from the state police. She kept her independence, as a medical examiner should, and she told you, no, I can't declare that, and she's not making any allegations about that. And then he wanted to, as you know, yesterday, and this is what caused my rant today, perhaps suggest she didn't do a good job. She didn't take pictures. She didn't take an X-ray here or there, because this collision that John O'Keefe would have had likely would cause he said something about a hairline fracture. What the hell do you know, sir? You don't consult people like that, okay? Because all you want to do is tell people what you think, all right? Dizzy says he also used Trooper Paul's spreadsheet of driving distances. Yes, he did, because the whole point is it started for the odometer. So he cherry-picked what he wanted to use. And what Judge Kenney did is take the evidence rule, which says you can't question an expert about other experts' findings, right? But that's not the issue. The issue is he used other experts' findings in a way that he cherry-picked things that he thought was important that would support him, but didn't use the other experts' findings in another way. It's a whole different analysis. It is violative, in my opinion, of Karen Reed's due process right for the Sixth Amendment. And remember, this is a whole change. We've had many changes of how the theories are. I mean, of how Karen Reed did this. The first trial, she backed up 70 feet, 24 miles an hour, full-on collision into John O'Keefe. Then you have Hank Brennan openings that she backed up 70 feet going a certain miles an hour. Then you have this guy gets on the stand. He's got 87 feet, but he's got 34 feet forward first and then 54 feet backwards and all. Just totally ridiculous. And he doesn't account, he didn't account for the Jeep that was there, the Jeep with the big, the snow plow in front of it. He didn't account for the other car that was there that was letting people off. He didn't account for anything. And we all know, and the jury's seen how small the area is in front of 34 Fairview. So we start that day with that, okay? And that led me to my rant, which you will see afterwards. And then Leslie yesterday, who I think let the expert kind of get away from him. I won't say got the better of him, but got kind of let the way from him. Apparently X is down. Oh my gosh, wasn't that interesting? X would be down, but X will be back up, I'm sure, within a few hours, but a lot away from. So then we did that, and then he went on and he wanted to said he asked exactly what we pointed out last night on our show. on our show. You can go back and listen to it. We had Aidan Carney on. It's a good listen, and maybe we'll play some of that show. Well, there's no lunchtime, but maybe we'll play some of that show when they take their early break today at 1:30, so you can listen to that show, which was, in my opinion, excuse me for touting our own horn here at Justice Serve TV, very good. And we said the judge has to tell him to stop looking at his Apple Watch. It was on his other wrist when you were looking at him, but he was looking at his Apple Watch, and you could see him looking at his Apple Watch. She had to tell him to put his laptop down because he was actually Googling, answers to information, answering it. So he wasn't able to do that. And today, Leslie said he asked him not to look at his watch, and the judge said, "Don't look at your watch." And then he also almost started arguing with it. But Your Honor, I get my emails on that. Well, he doesn't need to see his effing emails while he's on the stand in a murder case, unless those effing emails are telling him something. All right. But then he couldn't look at his watch. And I think that set him off, because all of a sudden after being on the stand for 2 days, today he wasn't in control, right? Today he wasn't in control. And then unless he went on to the glass on the bumper, and you don't know where it came from because there was no determination that came from the glass. He said, well, we saw John O'Keefe. I'm going to use my bracelet that my husband gave me as this glass. We saw him holding a glass, right? We saw him holding a glass. So what does that mean? You saw him holding a glass. It didn't match. There was no scientific evidence that it matched. There was none. And he said, so he saw reports. So he knew he was caught there. All right. He knew he was absolutely caught there. And then we moved on, not only to the glass, we moved on to the fact of the Ring cameras. Okay. We all know that the Ring camera was replaced at 34 Fairview. Well, the whole scans that they did and all at 34 Fairview was in the basis of the new Ring camera. And this guy tries to say, well, we accounted for those differences. You can't account for those differences because you didn't know where the Ring camera, how it was positioned at that time. You didn't know the spatial positioning of both that Ring camera. You know who everyone has Ring cameras. You can kind of tweak them a little bit, turn them a little bit, right? And the jury doesn't need an expert to tell them which way the wind blows, right? Because we all know about Ring cameras or Arlo cameras or anything like that. He said, so they didn't have it. And he said, well, it was angled more to the right. But when in a case where inches matter, you didn't really know what it was. So you had to make a lot of assumptions here in it when you concluded that maybe that the Lexus didn't hit the Traverse. I mean, it hit the Traverse. We saw the Traverse move. Okay. If I hit this and I throw it away, we see it move. All right. As a matter of fact, it's just ridiculous. And then it turns out he didn't have the suspension heights of the cars at all. And you can put a car in a different suspension when you start it. As you know, you can put it in and it may make it doesn't go up to the 20 inches until maybe up higher until maybe you're 20 miles an hour. But when you're sitting there, you can actually hit your suspension. Your suspension will go up when you sit there before you start. He didn't have the suspension heights of the car. All he had was the suspension heights when it was later at the inverted video garage in the possession of the state police. By the way, the reason why it was important with regard to Trooper Paul is because Trooper Paul has that one event, that almost so important event, as Alessi pointed out, occurring with the 3-point turn and all, while the car is in the possession of the Massachusetts State Police, because they had to make a 3-point turn to put it on the tow truck to take it over to the Sally Port. All right, so that's why that became very important with Trooper Paul. And you know what? The prosecution knows this, which is why we labeled our thumbnail today, Cover-Up Continues. Because we made a determination last night that this is a cover-up at this point now. I'm not even putting a question on it, because when you're trying to withhold the truth and you're the prosecutor trying to withhold the truth of what you said in the first trial because you don't want the jury to hear it because this is a new trial, that is a cover-up. Because you're trying to hide all the things that are bad for you. You're trying to hide all the things that you said happened. You're basically lying to this jury. Now, they don't know that. That is the problem. We know that. They don't know that. All right, this jury's sitting there. Okay, so we talk about the suspension height. So he assumed the suspension heights were the same. He made an assumption, and if you make an assumption, you know who the donkey is. Okay. And apparently there were all these assumptions that he finally had to give into. Okay, you know, so he didn't know. He didn't know about the locking. He didn't know what the suspension height was. He didn't know where the angles were. The cameras were angled when he did that supposedly reenactment to try to tell this jury that the car didn't hit. But more importantly, that rear tail light of Karen Reed's has these fins on it, right? It has these fins that go around. All right. And that's where we see the breakage, right? At that point, when she's driving, we can kind of see a little bit of that breakage, but not in the back, right? We see a little bit of that breakage. Well, and then on his 2D photographs, and when you have 2D, you only see two-dimensional as opposed to 3D or 4D. You're not seeing the whole thing. I mean, you don't need an expert to tell you the difference between 2D and 3D, okay? If everyone's gone to the movies. 3D shows those things. Well, it didn't show it. Not only that, it hit it. It hit those fins that go around that he didn't measure, by the way, that easily could have hit, and I believe absolutely hit the traverse at that point and fractured it. Because you know what? If you're going to take what Karen Reed says, well, take what she says in everything. She says that she hit it, and she said, look, I broke my taillight. And as a matter of fact, we know that there's going to be a Dighton cop that's going to talk about the taillight that when it went into the Sally Port, it was a Dighton cop or Canton cop, taillight that went into the Sally Port that, you know, only had a little tiny bit of a fracture in it. And that fracture had to be caused by hitting that traverse, not hitting John O'Keefe. All right, so that's a problematic to me. So that whole reenactment that they did, or not, I say reenactment, was, in my legal opinion, bullshit. All right, and if I were in the jury, I would be arguing that. Okay, I don't know who the jury is made up of, because remember, we don't have any of these information. But boy, that to me, that is garbage. Okay, and then we get into the fact that a tech stream event doesn't show a collision. Yeah. So when he's trying to say that all his analysis shows a collision of John O'Keefe, he doesn't have any tech stream event that shows a collision, because there's none shown at the traverse and there's none shown at John O'Keefe, right? There's none shown at the two locations. He's deducing that. He is deducing that there was a collision based on the going forward and the backing up. That's what he's doing. That's all he's doing. That's all he's doing. And we know that's a problem, because the key cycle that he's using, because he's not using key cycles, really occurred, the three-point turn occurred at Crestview, and the three-point turn occurred at the Sally Point, okay? You know, and if you have Karen Reed going forward, there's no way she hits him. If she's going forward, there's no way she hits him. He's got to assume a three-point turn, and there's no indication that there's 3 3-point turns on that data that they looked at, okay, at all. So unless he ends with that, he also talked about, and this is something I thought I posted last night from, it wasn't from Richie at Microdots, it was from another person who analyzed the fact that their use of the Bosch data, okay, because it is Bosch data, it is Bosch that you have to use to download this data, is different. There's another issue with another software that not necessarily give you the same numbers. They don't convert necessarily the same numbers, okay, with regard to the traverse. So you had a lot of problems. I thought Alessi was very good on point. I think that he showed how condescending it was. At one point, the judge did tell him, could you just answer that question? Because what his idea is to filibuster. He's like a politician when he's not as good, okay? Because politicians a lot of times are likable, right? He's like a politician, but not as good. He was trying to filibuster the answer by giving all this other stuff that has nothing to do with the questions that are asked. Now, my style of cross-examining him would have been different. I would have gone right at him, and considering the fact that he doesn't like people like us, okay, he probably would have shown his disdain for me, and then I would have clearly shown my disdain for him. So let's go to some of your questions. As I posted before, Judy Clark is a new member. Okay, all right, and our Q is a new member. Welcome. Thank you for coming to the Just to Serve TV family. I think you will like it here. Now, Luis P. on another issue. Oh, I see the fan. Said, Linda, can people outside demonstrate? Now, let me see if I can read to you exactly the portion of what the court said. Hold on a second. Oh my gosh. The court said, the buffer zone as applied was unconstitutional. But a woman's sweatshirt with the words "criminals control Norfolk County" does not violate the state's judge buffer zone order, the court found, but the judge ruled that her hat, Free Karen Reed, did. So you can't use that. Taken together, plaintiffs have shown there is a likelihood of success on their claim. So basically what the court ruled, and let me go back and find exactly the wording. Sorry, I have a lot of things open here to be able to tell you this. Hold on a second. Is that you can, and I wanted to get the actual wording, and I think, okay, we have it up here. All right, hold on. Let me see if I can increase my screen so I can see it with my eyes. Okay, let's see. Hold on. Okay. All right. I think there's a previous page let's see if we can go to the previous page. Irreparable harm, faulty balance of public equities. Let's go to the previous page too. The judge actually gives examples. I'm looking for the point that the judge actually gives examples of what you can wear here. Okay, hold on a second. Here we go. Let's go back to that. Let's go one page forward. It was in the, okay. Other examples of protected speech would include the following. We demand justice in the courts, fair trials, fair system, accountability of the courts, reform criminal justice. Also permissible are signage and messages that defend the protest's legitimacy without focusing on the trial or its participants. For example, the following would be protected speech. The right to protest is sacred. Dissent is patriotic. Convict Karen Reed will also be an impermissible image. Direct images that convey threats or pressure are not permissible, such as convict or face consequences, no justice, no peace, you've been warned. I think you could probably put no justice, no peace, but not you've been warned. We knew you were live. That can't go. So implied gifts, implied threats can't be protected in the buffer zone. But if you want to protest any type of speech and say, criminals control Norfolk County, or you want to say we demand justice in the courts, or you want to say fair trials, fair system, or you want to say accountability of the courts, or you want to say reform criminal justice system, or you want to have messages, the right to protest is sacred, dissent is patriotic, or you want to have something like, go First Amendment. First Amendment applies here. Anything that gives you the right to protest against the government without actually protesting the prosecution or of Karen Reed or the defense of Karen Reed is not allowed. So that's pretty clear. Okay, that is pretty clear. So Jason Grant, you are protected. Erica Walsh, you are protected. Michael Bryant, you are protected with our. Let me see if I can reach down here and pull it out. Hold on one second, because I do have it right here. See, although it's not, doesn't have the same. Justice Serve TV, okay, this is protected. Taking interviews with Justice Serve TV in the buffer zone, okay, that is protected. All of those things are protected. That's what the First Amendment was about, to protect the government, right? Or to protest against the government. Joanne Jetta Platypus, member for 2 months. I appreciate you, Michael, Mod Squad, and community. Thank you very much, Joanne Jetta Platypus. And 007 Texas, can defense play longer excerpts from the pieces out of the context of the clips they've shown? Yes, they can. Although it's interesting that they didn't ask to do that. They agreed to those clips. They didn't ask to do that. So we will see. We'll see what we have. We got the page. It was in the footnotes that the judge gave specific examples. It's a wonderful opinion. If you have a chance, John Matus has it up, I believe, on his X account, if X is working. John Matus was a lawyer who obviously was on the other night, and he represented some of the local groups, including the press that were involved in that. Okay. Yeah. Elliot Jamison has a question. Do you think she should stop after court? No, I think that her lawyers are telling her exactly what she should say. And I think her statements have been good after court. I don't have any problem with them. Whether or not she should have talked to, I would not have had my people talk to the magazines unless it was particularly scripted and I had control over what they then we're able to publish, but that's always a hard thing. But I've had situations where I knew there was going to be a gag order, and I've had my client do an interview beforehand, the network would hold it, and then they played it afterwards. And we got to see it beforehand. We couldn't say you couldn't run it, but we got to see it. We got to be there. And then it ran, during the trial after the jury was selected, so that there was no indication that the jury was selected. Okay, we have apparently, hold on, Michael Bryant, okay, Michael Bryant, who said, just texted because he asked where the world is justice, and we have a winner. We're going to post the issue on that. We have a winner. Somebody had said, because you had to post where he is and what the case he was on, and somebody had said he's in Venice. Oh, I want to go to Venice. I love Venice. One of my favorite places in the world. All right, but we have a winner, Leon Lately. It's going to be put up here on our link. I think you're on Praia de Luz, Portugal, where Madeleine McCann went missing. Am I right? Either way, and I don't have the full text because he's texting me from where he is. Yeah. Then it says, Tanya Berthold, I'm first. Love you guys. Free Karen Reed, free Turtle Boy. Note the first winner with Justice Serve TV, Praia de Luz for McCann. That would be, I think that's Leon Lately. Okay, but we're going to post that. So we have a winner. So you now know that Michael Bryant's in Portugal, Praia de Luz. I think that's how you pronounce it, where Madeleine McCann went missing. And yes, congratulations to Leon Lately. Okay, we have our first winner. I think he's going to do 3 of those this week as to where he is. It's going to have to be the specific city and the specific case that he's talking about. All right, so let me see with regard to some of your comments. Here, hold on a second. Okay. Boy, there's a lot of comments here. Okay. Yes, would you call the Barrows? That's who I was thinking about, the Dighton cop, to give Alessi a breather and Yannetti an outing on ARCA. I kind of like, that's an idea. I think whoever they call first has to be a slam dunk winner going into the weekend, if indeed that's what's going to happen here. I think you're going to find that we're going to have some redirect by Hank, maybe a small recross, and then remember the judge is ending at 1:30 today, and it may even be sooner. And then the question is what's going to happen tomorrow. I thought there would normally be motions, but last time the judge did not have motions in public. They were apparently private. She doesn't want people to argue their cases in public for the directed verdict. And you know they had to be, the defense is making them because you have to make them to protect your non-constitutional claims. And by the way, thank you all for, I'm wearing all my Justice Serve TV gear, including the new sweatshirts. There's a lot of different colorations that are out. And I know a bunch of you have bought them, and I did read your thanks that you sent when you buy them on the merch page. Yes, on the merch page. Now, we're going to have to go into a makeup line. We're going to have to get jewelry, all that kind of stuff. All right. So First Amendment attorney. Okay, let me just see. Let me see. All right. No, yeah. Linda and Michael, I'm so glad to be part of your Justice Serve TV family with a big loving emoji. Joanna, Joanna got us, as you know, we tracked her down to be on the show. And then to making account, Justice Serve TV community is one of a kind. Michael, Linda, and mods and chat have come to feel like extended family. Keep fighting the good fight, JSTV, to making account. And I will say that, if you like your hoodies just a little bigger, as most people do, they're absolutely true to size. If you want them a little smaller, and a little tighter, if you don't want to wear like a shirt under them, then you should, then you really maybe get a size smaller. I am taking a size small here. If I'm going to wear a tighter hoodie, I would probably take an extra small because they're unisex sizes. So that's not on this case, but I just thought I'd let you know because we do have a bunch of orders coming into the store, and many of you send those wonderful messages that we really like. Okay. All right. So Micah asked, so can I show up and wear yeah, you can. Yeah, yes, you can. That would be okay. That's protected speech. All right. That is protected speech. You can. Okay. So there's no doubt about that. let's see what we have. I think guess what? We're going back in. I was going to answer more questions. I think they need Trooper Paul to prove the triggering event. But the only problem with Trooper Paul, then he's going to say that Karen Reed hit John O'Keefe, so you don't want that. So we'll see what they call him. I don't think they're going to call Trooper Paul. But thank you all. Okay. Let's go back into court. I'll go behind my 2V avatar, but I am here.
Can you redirect, Mr. Brennan?
Thank you. Good afternoon.
Good afternoon, Mr. Brandon.
You were asked some
Actually,
questions.
it's morning, but yes.
You were asked some questions about the ring video from Meadows, which was John O'Keefe's home. And you were asked whether you're aware if the cameras had changed over time.
Correct.
The fact that the camera was replaced, does that any way affect your opinion to a reasonable degree of engineering certainty about your conclusions relative to that touching between the cars?
Absolutely not. It would have shown up as increased error when we overlaid the point clouds onto the photos or the point clouds onto the video. If it was an error, it would have showed an error.
Do you have any concern whatsoever that any of the information from the scan is in any way tainted, compromised, or inadequate?
That would be very hard to do. You literally press a button and stand there and watch it, and the laser does its thing. So I have absolutely no reason to disbelieve it. Additionally, again, if it was messed up, once you laid it over on top of the photograph, it would show the difference. So no, the data's fine.
Is there any evidence whatsoever that you've seen that any parts of your presentation were photoshopped?
No.
You were asked questions about the suspension of the motor vehicle of the defendant's Lexus. Do you have any information that the suspension at any point was changed?
No.
Yesterday, you were asked a number of questions about formulas. You took out your calculator and you were asked about different variables. Were those variables hypotheticals or were they related to this specific case?
So they seemed hypothetical. Again, you have to be careful when you're talking about failure forces on biomechanical things. For example, if you impact the hand with a, say, 1-inch narrow metal bar, that's a lot different than if you have a broad, say, plastic taillight or rear body panel. So when you have distributed loads, you can take much more. I told you guys about sitting on the bed, like how much you sink in. That's an example of spreading your load out. When you spread the load out, you don't sink in as much. So same thing with, forces on your body. If you take this pencil, I don't have to press very hard for it to pull in. But if I spread it out, I have to press much harder. So you have to look at the distribution of the load when you're talking about the failure. So when you look at the failure loads, it depends on what you're doing it with. If I hit you with a 5-pound 2x4 or a 5-pound pillow, they're both 5 pounds, but you'd much rather get hit by the pillow than the 2x4.
When you were asked questions about communications, when you would have communications with the Norfolk County District Attorney's Office, did you ever use encrypted apps to secretly hide your communications? Apps like Signal?
No, I don't have any of those.
So the form of the question, ask it differently.
When you were communicating with members of the Norfolk County District Attorney's Office, did you ever use encrypted apps like Signal to communicate?
I'm going to allow it.
No, I mean, I don't even know what that is.
What?
Would you ever use an encrypted app? So
Unless he didn't talk about
tracked?
apps,
No.
encrypted
apps?
apps.
As a professional for doing that.
This is so wrong.
You were asked about confirmation bias. You remember those questions?
I do.
Could I have slide 33 of your PowerPoint, please?
I'm sorry, what number?
Slide 33.
Give me a second. 33.
You could zoom that in, please. A little larger so we can see it.
I cannot do it with one monitor.
You can't do it any closer than that?
Not since I took down. Oh, hold on. Oh, here we go. Which part do you want me to zoom in?
Miss Gilman can zoom in for you.
Sorry? Which part?
Miss Gilman's going to do it for you.
Oh, there you go. Perfect.
If you could zoom in, please. Okay. On shift position signal, going forward, then neutral and reverse, does that data suffer from confirmation bias?
No, that's strictly electronic data.
When we look over at the vehicle speed, can we go to the left a little bit? Down. Vehicle speed ending at 2361 miles per hour. Does that suffer from confirmation bias?
No, again, these are direct readings from the vehicle. Again, that speed on this here, you have to correct for the slippage, which I do later on in the slide, but that is a direct reading from what the speedometer is seeing.
Acceleration at the end of that 10-second window, 74%. Does that suffer from confirmation bias?
No, that's a direct reading of a sensor. That's objective information.
I have no further questions. Thank you.
Wow.
Anything, Mr. Lessie?
Well, so we had some snake question to begin with. And then the other thing is, well, can you change the laser or not press a button? Well, that doesn't answer what the inputs are that you put into the data after you press the button.
Yeah,
That's
Your
the
Honor.
problem.
Thank you.
Let's see what
Dr.
Leslie does
Welcher,
with it.
you were just asked questions about slide 33, which is the slide about text stream data. You acknowledge that text stream data, what you have called a trigger, like was on that slide, does not tell you if a collision even occurred, correct?
Correct.
With regard to the topic of confirmation bias that you were just asked about in slide 33, am I correct that all of the questions that Attorney Brennan just asked you were about data on that slide, correct? All that's on that slide is data, correct?
He asked me more questions than just this slide.
But were the questions just about data?
On this slide, it was just about data.
Correct. But confirmation bias is really aimed at opinions and conclusions and alternative hypotheses. Isn't that what confirmation bias gets at?
So generally, yes. Again, I started this case.
Thank you. Yes.
with
It was
the
just a question.
hypothesis,
Go ahead, sir. Go ahead.
with the hypothesis that the Lexus didn't contact Mr. O'Keefe. And so I start what's called the null hypothesis, that this didn't happen. And then I look at evidence to either include or exclude the null hypothesis. So theoretically, my confirmational bias starts with a bias that it didn't happen.
Can you point to one document that shows that you analyzed whether there was no contact between the Lexus and Mr. O'Keefe? Can you point to one document? Was there one document on your slide presentation that analyzed the null hypothesis, as you call it, there being no contact at all? Was there any slide in your direct testimony?
So remember what I said, we start with hypothesis, we get more data, we whittle down our hypothesis to the final answer. I mean, I had 130 slides. I suspect I bored some of these people to death already. So I didn't include everything. There's thousands
Right,
of
you didn't
photographs
include the
in
null
here.
hypothesis
There
that you
was
say
a
now
bunch
you
of
make
testing I
makes
did
you
with the Lexus about
honest.
backing, pedestrian detection, that, you know, removed certain hypotheses. So if I was able to eliminate a hypothesis, I didn't present it here.
Sir, my question is not about you.
All the slides show that, to answer your question.
Sir, my question is there any slide that says alternative hypothesis 2 whatever the label is, whatever the term, it says no contact between the Lexus vehicle and Mr. O'Keefe. Is there any document that you presented to the jury that shows that?
Any document where those words are written on it?
Correct.
No.
And to work through hypotheses, different ones, in confirmation, and to see whether there's confirmation bias, have you heard of scientists refer that as showing your math, so to speak, in working through hypotheses, documenting each hypothesis and how and why you rejected them? Have you heard of that term in the scientific world, show your math with confirmation biases and alternative hypotheses? Just a question. Have you heard the idiom, the phrase, show your math?
Your question is, have I ever heard show your math, period?
Associated with the application of various hypotheses to avoid confirmation bias. Have you heard of that term used in that conjunction?
Not really in that
Okay.
context. It's probably, I understand where you're going with it.
Thank you, sir.
You're welcome.
No further questions.
Dr. Welcher, you are all set.
Oh my God, thank you. Give me a minute to pack up and I will be out of here.
Okay, he's finished.
Oh, yeah, I'm plugged in. Yes,
Okay,
thank
that
you.
was a very short redirect by Brennan, and he tried to be a snake about the signal because we know ARCA used signal. Well, you know what? When you're in a high-profile case, you tend to want to use signal. It's encrypted, okay? It's encrypted. Signal is encrypted. My volume is controlled not by me, okay? So we'll tell Missy that my volume is controlled with the court and here. Sometimes I will shout to make a point. All right. So that was very short, but you know, in high profile cases now you have to do that because you can't have people getting access to your texts and your email. You have to use an encryption. And as a matter of fact, if you don't, you could be subject to malpractice. Many law firms now have all sorts of encryptions in documents that come into them and emails that come into them. And if you don't, you have to put that in your retainer agreement, at least in New Jersey where I'm from, that you don't have those encryption abilities when people contact you. So there's nothing wrong with encryption.
Yes, thank you very much.
But that was a snake event because there was nothing asked about that on cross. And you know what? There's no consequences, right? There's no consequences for being a liar in Judge Beverly Cannoni's court if you're on the prosecution. Or being a sleazy attorney if you're on the
Commonwealth
prosecution.
moves to introduce and play clip 26.
So I thought, could I have run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
Exhibit 207.
Your Honor, the Commonwealth rests.
There you go. The
Does
clip
counsel want to see me?
and the Commonwealth rests. Does counsel want to see me?
So should we send the jury out or should?
So jurors, so everybody can sit. So jurors, the Commonwealth rests. That means that the Commonwealth's case has been presented to you for your consideration. So I need to meet with the lawyers for a few minutes, so we're going to send you back out. I I can tell you that it now appears that we're at least on schedule, if not a little ahead of schedule. So we'll send you back out for a short recess.
Right. Can counsel come to sidebar, please?
Okay, so this is for two reasons. I mean, I guess she's going to talk about the motions to dismiss. If you're going to make them, she may want them in writing. I don't think she's going to let them occur in public. She did not last time. She doesn't want people arguing their case in public. That's not necessarily a bad thing, okay, in my opinion, because you get everyone. It's great for the defense, maybe not so, maybe not. Usually for the defense, they just say they rely on the evidence, blah blah blah, with the motion for a directed verdict. But she doesn't want to have the defense make these arguments in open court, and they may not want to make them in open court because they don't want to give away their closing. Because your motion for a directed verdict, and many times reflects your closing. So. Elliot Jemison asked, how many times have you seen a case proceed without the lead investigator? I've never seen it, Linda. Yeah, I saw a case recently without the lead investigator. Usually it will happen when somebody is deceased or is terminal from cancer. It's not because somebody has been fired, as in this case, but yeah, it happens. What you're seeing here is a high profile case. And what we see a lot of times is a cases that, I don't say one run of the mill, but in criminal attorneys, there's a lot, you all watch Law and Order. There's a lot of cases that hit. And yeah, I have seen cases where the lead investigator is not called, but not in a high profile case. Usually the lead investigator is called, or the lead criminalist, or whoever is in charge of the investigation. But there is certainly something for the defense to make the heyday about, that he's not called. And I think that's why you're not going to see them call a lot of these people. They want to argue the prosecution didn't call these people. The prosecution didn't call them. Now, the only thing I noticed that Alan Jackson did say, by the end of this case, you will have no doubt that John O'Keefe entered that house. We saw that from Ian Whiffin's slide, but we don't have Higgins on the stand, who said that there was a 6'2" person with dark hair in the house. Didn't want to say John O'Keefe. And then there was another witness, I believe, who said that John O'Keefe entered the house. So the defense has to do that. I don't think the prosecution's shown anything. I think if this were a normal trial, it's very possible that the murder count, the high count, could be dismissed. Although, what happens is judges just let the jury do it, and if I think there's something different, I'll deal with it at the end with a judgment for acquittal. But yeah, that's where we are. So they're relying on the fact that number one, that the jury will hate Karen Reed. Number two, that these statements that seem were maybe not the best statements for her. Again, I would prefer that she had not made a lot of these statements, but a lot of them actually were helpful, like her explaining the drinks were helpful. And all. So I do think that that's an issue that the prosecution has that may help them. You have here the ARC, they're relying on this ARCA guy, who we know is different than all the theories in the plan. It's not ARCA, on this aperture guy, I'm going to call him, that guy. I'm going to give him the same respect he gave Dr. Scorty Bello. Now, our friend tonight, who's going to be on, does know him and does think, I said he's really thought highly in the reconstruction community. But in this case, I can't think of him that highly. I think his attitude was terrible. I think his way he answered questions was terrible. And as I told you, I was done with this guy once he called Dr. Scorty Bello. I wouldn't consult with people like that. A woman forensic pathologist. Do you think a forensic pathologist is beneath you? Well, I have two words for you, and it begins with F and ends in K, and it's not fire truck. Okay, so to make it count, the way Bev says, for now we appear on schedule. She's insinuating if we're at schedule going forward, it's the defense's fault. Yeah, everything is the defense's fault, right? Everything is the defense's fault, okay? Everything, is, she blames the defense. Now, and with Alessi this morning, her ruling this morning was just, I'm denying your motion. That's all. She didn't give reasons for the denial of the motion, although us lawyers kind of know what they are, but I think they were wrong. And also, interesting issue, what do you think if they were sent to deliberate now? Just curious. Well, you know, I don't think that the prosecution has proven to me beyond a reasonable doubt what happened. I don't know what happened that night. And if remember, at this point, this is the best that the prosecution's case is going to get. Okay, this is simply the best they are going to get. That the high point of their case is when a prosecution rests. And sometimes, you know, you're in a case and you say, oh, you know, because you're worried about the jury having kept an open mind. The prosecution's case only gets worse from here, especially when the defense decides to present a case, as this defense is going to do. They're going to present a case. They're going to present Dr. Leprosada, forensic pathologist. I don't know if they're going to call the forensic neuropathologist from the stand. They're going to present the pathologist that the FBI hired. We know they're going to present the 2 ARCA witnesses, and we know exactly where Hank Brennan's cross-examination is going to go. It is no surprise. And of course, I think that the judge is absolutely wrong, again, not allowing them to know they were hired, not allowing the jury to know who they were hired by and what their charge was to do, who they were hired by, what their charge was to do. All she has to do, or even what their charge was, who they were hired by. All she has to say, you don't have to worry, ladies and gentlemen of the jury, as to why they were hired. That's not of your concern. We're just giving this because this affects your judgment of their bias and their credibility. And that's really what it comes down to, if they were hired by a third party. Now, they then converted after the trial to get a bill and now hired by the defense. But apparently, from what I gathered from Alessi, that there's nothing that's changed in the ARCA reports. Now, I can't imagine that they wouldn't have gone through and discussed what the problem is with I hate to say his name, Welcher's report, but maybe that's where Alessi got his cross-examination from, you know, as opposed to having a change in a report. So we're going to have to see. So the defense case supposedly is going to last 2 weeks, and I think that 2 weeks is because they expect Hank. You know, we've seen how Hank Brennan questions. You know, remember we have Dr. Marie Russell. We're going to have the defense dog bite expert because the jury right now doesn't know. Have an alternative theory as to what caused the dog bites. All they heard was that there was a dog named Chloe who was rehomed, and somebody went to take a bite mold of some dog that veterinary papers didn't have the full name of the dog and the age of the dog and all sorts of stuff on them. So they don't really know that yet, right? We know it, and it's hard sometimes to separate what we know from what the jury knows. Now, of course, as we all know, as attorneys, the jury, after the opening statement, has a bent. They haven't made up their mind. People say made up their mind. We used to think that's the case, but it's a bent. It's a bent that they carry with them and that could be undone or cemented. But you know, the jury in this case is apparently very attentive, I gather, and we will see. The danger of the case, I think, for Karen Reed is because of her statements, count 2, about whether or not she could have hit John O'Keefe. But the problem is that if you think, you know, you're searching, right? You're searching. You just took care of the man's guardianship children, basically for a 3-year period through COVID, and you know, you. I don't find those statements of her, by the way, in the phone calls where he's trying to gaslight her and all. I don't find any of those statements helpful to the prosecution. I view them as look, she knew this relationship was, she was angry because she felt used, but she was going to move on. She was exploring it with Higgy, who, I mean, to me, the worst judgment that I see from her is that she thought Higgins was hot. But I can understand that if you are feeling depressed, dejected, rejected, and your self-worth is down, that, you know, you'd look for somebody who you think is interested in you. I can understand that. And I think that anybody who's ever had a friend who's been through a relationship, most people have been through relationships, feel that way. And I didn't see any problem with that. I mean, he was going to use her for a ride that night, and then she got annoyed. You know, she was sitting out there waiting for him to come out. He didn't come out. And she left, right? And she didn't go back to Braintree, which is where she had come from after going to his house to pick him up, where she has a house of her own, and she wanted to sell it, and she wanted to move to Tiverton. She said that in those conversations with Higgins, right? She said that she went back to still take care of his children, and I say his children because they are his by virtue of the guardianship. And one was away, and the daughter was at home. So that's how I viewed that. I found that to be perfectly reasonable and not a motive for murder. I'm going to all of a sudden kill him. Now, this at most is a DWI leaving the scene of accident with a death, right? It's not an intentional homicide, and it's not an implied malice murder, which is what Massachusetts basically has. For those that are familiar with it, it says you're doing an act that you know is so recklessly and dangerous that it could result in the death of somebody. Okay, basically that's it. So we'll see where we go. I mean, it's interesting that this witness here, Welcher, says, well, those pattern injuries on the right arm. And by the way, oh my gosh, I'm gonna have to stop right now and just put this up because I just saw this Jersey girl became a new member. Woo! I'm from Jersey. I'm a Jersey girl through and through. I have my son in the other room. Once a Jersey girl, always a Jersey girl. And I assume you're talking about New Jersey, not Jersey over in England, the island over in England. So welcome, Jersey girl. Join the other Jersey girl here. And sometimes we have Bob Bianchi on, who's a Jersey boy. So we'll see. But those arm things that he said, there's puncture wounds in those arms. There's puncture wounds down the sweatshirt in part, not all of them, which may indicate that it was pulled up or whatever. Elsie Jones, I'm married to a Tom's River boy. Oh, yeah, my assistant, Patty Hulbert, who's sometimes in the chat. She's from Ocean County, too. I had a beach house in Ocean County, which I sold because it wasn't like my childhood when I was from Red Bank, New Jersey, and everything was wonderful at the beach. It's really crowded now at beaches down in Jersey. Okay, anyhow, but I digress. So whenever there's Jersey talk, I digress. But it doesn't explain all the wounds. He's got that. He's got rolling. Let me just roll 2 miles an hour and let me show you the roar of the grease paint, the smell of the crowd. It's a ridiculous. And the one thing that I thought Alexei should have gone in is he said at the end, initially Welcher thought that was a test, and the blue test. But then at the end he said it was experimental. And I think if I were to fault Alexei yesterday, is he didn't grab hold of that experimental. It didn't grab hold of that experimental. He didn't grab hold. I'm going to say it again. He didn't grab hold of that experimental at the end when Welcher said it was an experimental test, because experimental tests are not science until they're validated by a whole bunch of people. That's the Dahlberg hearing. Remember the Dahlberg that the judge find that his methodology is bad. And yesterday also, when Alexei objected to all this, he said, well, I'm letting it in because you didn't make an objection on his methodology, experimental methodology. The defense has made so many motions. I reposted Olivia Lambeau last night. So many motions on the fact that everything that Welcher did wasn't Dahlberg satisfied. It wasn't experimental, et cetera, et cetera, et cetera. Okay, and quite frankly, it's just ridiculous. Quite frankly, it's beyond ridiculous that she said that, and to me that really has bothered me. All right, and it bothered me a lot as a lawyer. I've been in courtrooms where the judge just make it up, and that's just terrible. It's just terrible, because defense, if anything, has made motion after motion after motion. And did you see Hank's motion yesterday? I don't think we discussed that. I have it here. Hank's motion. Let me see. Hold on a second. They wanted to preclude the attempted use of any information not produced in violation of Rule 14. Now, what that was about is he was objecting to the fact that the defense used Shannon Burgess's other CVs from other filed cases, right, to cross-examine Shannon Burgess, and hadn't produced that in discovery. Well, when you're doing a cross-examination and you find that stuff by this guy, you don't have to usually produce your cross-examination material. unless you're in federal court, and then you may have to produce your cross-examination material under the trial memo that you file in federal court. That's ridiculous. It's a sleazy, disgusting, ridiculous tactic. And so we didn't discuss that because I didn't think very much of it, except that I think it was another sleazy tactic. And by the way, with Welcher, they actually treated him with respect. There's a case in Massachusetts. I am sure the defense had it where the judge ruled that his opinions are unreliable based on something we talked about yesterday. Cadaver testing, okay, is an unreliable method for analyzing how force affects live human beings. And apparently he was using his cadaver charts, again, we talked about, that are from somewhere overseas in 1979 or before that. All right, that how a body, when a body is impacted, a live body, and here you have blood vessels, and you have ligaments, and you have tendons, and you have bone structures, and you have hair, and very fluid. It's a lot different than a cadaver that is a dried out skull, which you've all seen pictures of everybody having a dried out skull, and then that breaks so easily, right? It's a lot different. Let me just expand. My thing here, my slide, evidence of liability, sure, justice of the Superior Court. Okay, yeah, this is another one. This is an order on Cavey versus Christopher. This is one on Cavey versus Christopher Simmons. That Judson Welcher was excluded. There was also a case in, I think, is this the California case or is this the Massachusetts case? There was two cases that they found that one was not because of his analysis. One was because he didn't produce photographs in a deposition that he said that he had taken to support his opinion, and he never produced them to defense. I just got a note. As you know, I'm friends with Cheryl McCollum, who's one of the best crime scene investigators in the United States. And she just texted me, the Commonwealth has rested without calling a lead detective, forensic pathologist, or an expert witness that has dealt with a dead body in person. This should frighten people. Cheryl, right on point. I think they didn't call a forensic pathologist because they couldn't get a board certified forensic pathologist who would agree with them. That's why when someone says to me, oh, Dr. Wolf, he was wonderful, he showed me. They went outside to somebody in Florida who does gamma ray surgery to remove tumors, who's never held the brain of a dead person in their hand and done an autopsy on it. And remember, I told you that the forensic pathologist and Dr. Priya Banerjee, that I told you, deals with all the people that are brought in dead, and she also deals with the brains of people that die who have gone to the hospital and didn't make it. The forensic pathologist sees all the brains. And to denigrate the mean, deny, and to go around, to do a workaround of a forensic pathologist, to do the workaround of a forensic pathologist. I see my computer just has a cracked screen in here, by the way, just so you know, in case you're seeing that. I must have dropped it. It is wrong, all right? It should frighten people. You don't have the lead detective, as we talked, although I've seen that before, but not in a high-profile case. You don't have any expert witness that's dealt with somebody who's dead. You don't have a forensic pathologist who rules on the cause and manner of death, who rules on automobile accidents, who rules on, Dr. Wolf wouldn't they be able to sign a death certificate in the state of Massachusetts? He was not licensed. He wouldn't be able to sign a death certificate for a suspicious death because he wouldn't by law be allowed to, okay? He'd only be allowed to, like if he had a heart patient who died, or if he signed something in the hospital with a brain tumor, somebody dies of cancer. But he is not an expert in that. And to go around and then to hire Welcher, who then dismisses a forensic pathologist, dismisses it, right? Dismisses a forensic pathologist on the basis, I wouldn't consult a person like that. And you want to come in and you want to tell us about a cause of death? Is that basically what you're saying? When you can't even tell us that in your thing that a car impacted anything, and you're making up the Blue Man Group? I think the Blue Man Group, I know they're no longer, but if they were alive, they probably should have sued Judson Welcher on this. It was ridiculous because that's what we all thought of, right? It was grease paint that comes off and all, and you can phony it. And the other thing that didn't show, he had the test about, let me tell you what you're going to do. You don't know how many times they did that test. You don't know how many times I did that test. I always tell people when I have groups, firearms testing, where you see the lab is said the lab a gun. They've dropped a long gun to see when it goes off, and they report on the one time it goes off. But they may have done 100 tests that shows that it doesn't go off, okay? And those are never in the final report. So we don't know exactly what they did beforehand to try to do that, you know, but whatever it is, I'll guarantee you that's not peer reviewed. And what his excuse is, I can't peer review because it's my testimony. Okay, let's go back into court. Let's listen to see what's going to happen. I think they're going to take the rest of the day off, but maybe I'm wrong. Let's hear. Okay. Unless he's still the only one standing up, but it looks like he's packing things away. All right, it looks like he's, so we'll find out what's now. This is, this is interesting because we see Alessi packing up his stuff. The judge is now talking to the court officer. We have no idea what's going on here, okay? Maybe the motions were made at sidebar and, you know, with regard to what the judge did, because that was a long sidebar, longer than you would expect if, you know, what's next, what's happening next. So I assume the jury must be coming in, okay? You know, but we're not, you know, we're not seeing the fan going up to the ceiling. Usually the fan goes up to the ceiling when they're coming in, unless they're going to release the jury. They, you know, there's a possibility that if they're finished for the day, they're just going to release the jury out of the jury room, which I've seen happen. They don't bring them back in to say, okay, we're finished. We're just releasing it. But, you know, again, as in everything else with this case, we all have to be a little bit secretive, except when we're screwing the defense and putting the knife through them. And then we're not secretive at all because we're trying to send a message. I'm actually going to, yeah. Can you imagine the Commonwealth trying to convict you? The government, let me put the government trying to convict you. Oh, here they are. They're in. She's bringing them in. Without a forensic pathologist, without a lead investigator, with a person like Welcher who does experimental tests. Can you imagine that? That's what they're trying to convict you on. They're trying to convict you on hate of a woman because you think that maybe that's the only excuse for what's happened here. It's outrageous. It's terrible. It's wrong. And this is why I do like being a lawyer, because sometimes we get to fix that, even though we take the daggers from some of you when you don't like our clients, right? We get to try to fix that and bring in some justice to the United States. Again, many times you don't like our clients, but it doesn't matter who you like. It matters that the Constitution's upheld. All right, let's go into court and let's listen.
All right, so jurors, we all, it happens several times a day, doesn't it? So we don't want to waste anybody's time. I know we've spent a lot of time at sidebar and we've had times that we've kept you in the deliberation room because we've been trying to sort through everything, trying to make this trial as efficient as possible, but also honoring and respecting all the hard work of the lawyers that's gone into preparing this trial. So sometimes I do understand that it's frustrating. But today we were able to spend some time this morning. I know we kept you in there almost half an hour and we just spent the time now. So I can tell you that we are ahead of schedule right now. I still need to talk to the lawyers about something tomorrow morning. So we're going to send you home now and have you come back tomorrow morning at 9:30, because today I know we kept you until 9:30.
Oh, wow. So they're expecting testimony, it sounds like.
Lawyers tomorrow morning to have you here for a 9 o'clock start. So tomorrow will be a full day and we'll have you here ready to start at 9:30. Okay, so those same cautions. Please do not discuss this case with anyone. Don't do any independent.
Looks like we're going to have witnesses tomorrow, and we will find out.
Or read anything about the case. please disregard it and let us know. And also, please continue to be careful with your social media use. So we'll see you tomorrow morning.
Surprise for the jury.
Sounds like we better have a thumbnail into tonight's show, Diz and
Ms.
Missy.
Cole, if you can get me whatever you're going to get me within the next hour, so that would be great. And I'll see everybody tomorrow morning at 9
Thank you.
Wow, within the next hour. All right, I'm going to make sure. Let me just check to see whether we can thumbnail into the night show. Hold on a second. Are we there? I'm not sure we do have a thumbnail. I do want to have a thumbnail that we can go into tonight's show, if possible at all, even if a holding pattern, because tonight's show is 6 o'clock. If not, we'll have it on our Justice Service TV website later on at YouTube. And we're going to have Stephen Plord on, who's going to give us his take, having testified on the same side and also against Judson Welcher, who knows him personally. He's going to know my take before that, okay? Because I'm going to play my rant tonight again. And that rant is going to go up on our YouTube page that I did this morning. He's going to take that. So we're going to have witnesses tomorrow. So Ms. Little has to get something to the judge that they discussed. Now, I don't know what that is. And we're going to, the word is going to get out as to who the witnesses have to be. So instead of 1:30 today, because I think she was expecting that Welcher would take a longer time on the cross-examination. And I think Leslie, once he got what he needed from Welcher, got in and got out. Okay. It was just, as you know, this was not, again, but you're right. In this case, not calling the lead investigator, it's just awful. Okay. In this case, we have Hank Brennan ending up his redirect of Welcher, which was not very long, was, I thought, awful with that slimy, snaky question, which almost tells me that maybe ARCA is going to be first, about you didn't use Signal to, and the Welcher said, I don't even know what that is. Signal is used all over the world. I have Signal. I use it all over the world, especially when you're talking about cases. You have to use Signal, because it's too easy for people to break into your apps on a high-profile case, okay? It's not nefarious. It's not anything. The government doesn't like it because it's encrypted, but there's a lot of other messaging apps that are now encrypted, okay? So, I mean, that was just a real sleazy, slimy question. And you have to wonder if any of the members of the jury on there use Signal, okay, at all. So it is just terrible. That was his really disgusting, snaky question. And it's that kind of snaky question that has made me feel that this is a really disgusting case against Karen Reed. Okay. And at this point, I'm going to tell you right now, I don't know what happened. They didn't prove anything to me, but I would be feeling like a lot of the people in Canton and Dedham are feeling, that there's something wrong in Denmark, or there's something wrong in Dedham, or there's something wrong in Canton. I'd be feeling that, again, people had to go to the First Circuit Court of Appeals twice to get a decision that they could protest their government and have First Amendment rights, okay, which cost time, money, energy, and actually resulted in somebody being hurt, and not by a cop, but by a state trooper. Apparently, from what we've seen, at least Mr. DeRozier is contending that from the being lifted up and pushing down, that he had to have some kind of surgery and some kind of sling. Our Michael Bryant was very careful when he went up there. He tried to get into with Karen Reed, but was very careful about the buffer zone, not letting us do a lot of the reporting that we would not like to do. Okay. It is so ridiculous here. So they're trying to get a conviction, knowing that their own people that they normally would rely on, the medical examiner is not giving it to them, that their own people, the lab didn't give it to them, that their own accident reconstructionists, the whole Massachusetts State Police has a whole unit devoted to accident reconstruction, that they can't really rely on trusting them, because they thought, Trooper Paul was hysterical. But you know what? There was a certain honesty with his hystericalness. He did have the key cycle that was very important, and the text stream data that was very important, located at the time that the car did the 3-point turn, getting onto the tow truck that took it from Dighton to the Sallyport. They didn't call, the prosecution didn't call the Dighton cop, Barrows, who said that Karen Reed just had a slight little fracture, maybe a small piece missing in her taillight, not the whole thing, you know, not 47 pieces. They didn't call Michael Proctor with the text. They didn't call Albert. They didn't call Higgins. They didn't call the two people, Albert and Higgins, who got rid of their cell phones. Higgins, as you know, went to the base, the federal base, where the state would have no jurisdiction, took out a SIM card, got rid of his SIM card, got rid of his cell phone, and then they changed carriers. They didn't call those people. They tried to hide all of that. And instead they called people who, in my opinion, made up, I hit him, okay? No doubt in my mind. You want to sue me? I believe that was made up. Not in any reports. You kidding me? Are you kidding me? And you know what else they didn't call? They didn't call the Canton cops, who said they never heard that, right? The 3 Canton cops who were supposedly in earshot of that, who said they never heard that. All right. They didn't call them. It's just ridiculous. The Commonwealth did call Proctor in the first trial, and they got out of the way, the text, they got all the good and bad in there in the first trial. So they did call him in the first trial, just so you know. But they didn't call all these other people that are problematic to them, that show that's exculpatory information. I think it is sleazy. I think it is snake-ridden. I think the Attorney General of the state of Massachusetts should be intervening. And if you don't think the federal government is not watching this, they're watching this, no matter what is happening in the Department of Justice right now. Because the experts that they use, ARCA, have been attacked, have been ridiculed. Remember what the doctor said when he got on the stand, that indeed his family had been threatened as a result of social media and getting all sorts of stuff that was terrible as a result of social media, because the Convict Karen Reed trolls were all on him. And his family and his kids and all that kind of stuff. I mean, but they don't bring any of that to the forefront, right? They don't bring any of that. All that they did was try to diminish and violate constitutional rights. They tried to take away the First Amendment right of all those people who wanted to come down and support Karen Reed, who wanted to be part of the social movement. Well, guess what? I would anticipate that they're going to be back pretty much soon, because people like Jason Grant, the other 2 plaintiffs in the lawsuit, Michael Bryant, Tom DeRosier, Erica Walsh, they had the, I'll say, sneakers to sue Judge Kenney, the Commonwealth, the Massachusetts State Police, for what is right. And I'm very proud to be associated with my streaming partner, Michael Bryant, to be part of that, as Justice Serve TV was a part of it, to try to bring the First Amendment to Canton, to try to bring the First Amendment to Dedham. I also say, and I'm going to tell you right now, this whole thing, I didn't even realize how it was connected to the Sandra Birchmore case. As you know, my husband was the one who broke that wide open, being hired by the civil attorney, saying that he ruled that was a homicide. He doesn't say by who, because forensic pathologists don't attribute blame. They can just say something is a homicide or not a homicide in their opinion. Natural accident, suicide, homicide, or undetermined. There's actually 4 causes of death, and then the final determination is undetermined. But it's called the NASH system, just so you know. So he broke that right open, and I didn't realize that there were a lot of the same interconnecting players here. And I've come to now feel, as we've gotten to know by our 11 trips up to Massachusetts, know the people that are involved here, the people that are trying to do right, and we've tried to bring them to you on our show. All right, we tried to bring you the Jasons, who will be on tonight. The attorney is going to be on tonight, who was on the other night. We're gonna have a show tonight with a couple of the same people that were on the other night, because we weren't sure that whether or not Judge June was going to come down with the opinion. And it turns out the reason why it took forever, and it really wasn't forever, it was only a week and 1 day, was because he was writing an opinion, and he was writing Judge June was writing Judge June was writing a very good opinion, an excellent opinion, one that really put the Commonwealth in their place, but did give them to 200 feet, maybe because it's a small area, maybe because there's a lot of public buildings around there that are owned by the by the county, and therefore you couldn't do it. But you know, they had to be put in their place. And Mark Randazzo, whether you like him or dislike him, okay, he fought for you. He fought for the First Amendment. All right. I don't care who he is, what he's been. I know what he is now, and that is somebody who fought for our First Amendment rights here, and did it very well. And the court obviously respected him because he said, "You have to do something, Your Honor. If you don't do something with the buffer zone, you have to do something with the enforcement." And quite frankly, you know what? The Massachusetts State Police should be happy about that, because now they've been told what they can't do. Okay, if you have something that says "free Karen Read" on it, okay, they can tell you to take it off. You can't be in that buffer zone. And I hope they tell you to take it off as opposed to picking you up or arresting you, because remember, they had their paddy wagons out that first day. You know, we'll give them one warning. If not, we'll arrest them. You know, stop being bullshit hard asses. Okay. All right. Work with the people that among you, and then you'll get respect. All right. And that's why we've been there, and we're going to go up our 12th time. We've been up there to try to get the respect of everybody up there, see what's going on, get the right information. And we thank Aidan Carney last night for being on our show. Okay. You have made us 14,000 strong during that show in 6 months. We hope to double that. But it's because, you know, we're not one of these 300,000 subscriber shows yet, because I'm counting on you to get us there. All right. But we're trying to give people respect. We're trying to give them a hearing. And we love having your input on here. We don't take nicely to trolls. Trolls will get, you have the right to say what you want, as long as in our chat, we did have a question last night that was just a bullshit question towards Aidan. We took it out. I took it out. Hey, you can write that question to us. That doesn't mean we have to put it on, because we are not the government. We are justice served, and we try to bring you justice served. Be respectful, like everybody. We're gonna keep having you come on and so at 6 o'clock tonight, I don't think we have a portal ready yet. I don't think we have a thumbnail portal ready yet, but it's going to be there. And if you hit that like button right now, the more than 1,000 of you that are watching, the subscribe button right now, I'm going to give you time. We do have a portal already up. Okay. For 6 o'clock tonight, we're going to portal into it. But if you hit the like button, the subscribe button, the share, and the notify, that really keeps us in that algorithm. That not only helps us, it helps you get your point of view out when we call on you, and we try to do that when we can. If you have a private message that you need to send to us, you could send it to @justiceservedtv@gmail. But let's remember what some of the things, let me see if I can pull up my little notes here of some of the things that the judge, by the way, the judge in the First Circuit, Judge June, said you can do. That was so important. Just bear with me so much, because I have so much information here that I try to impart to you with some degree of reliability. Let me see. Of course, I can't find it right now. Dizzy, do we have that third page? Let's go to the page which had the footnotes on them, because I really would like to end the show with two things. One, could be nasty. Screw you, Welcher, for calling Dr. Scortibello people like that. Okay, let me make that perfectly clear. That's my First Amendment right to say it. I'm pissed off about that. Okay. The second thing I'd like to say, you should all be really scared, as Cheryl McCollum says, that the prosecution is trying to convict somebody of murder by trying to go around people that they should rely on, their own medical examiner, by not calling and hiding the truth. Between what? Between their legs, Hank Brennan, okay? And you want to talk about hiding things and talk about signal. But let me see here with regard to, remember what the judge said. And the third thing, I know Joey just gifted five Justice Served TV memberships. We'll put that up in a second. Other examples of protected speech would include, we demand justice in the courts. Well, it's time for you to have your voices raised, demand justice in the courts. Fair trials, fair system, accountability of the courts, reform criminal justice system. Messages dealing with the legitimacy of government also allowed. The right to protest is sacred. Dissent is patriotic, okay? Dissent is patriotic. So you want to go out there now and you want to appear in that buffer zone with any of those statements on you, or you want to appear with Erica Walsh's at Microdots merch store, Criminals Control Norfolk County. Go to it. Go to their merch store. I'm going to hawk Richie's merch store more than I'm hawking our merch store today, because this is so important to give people the ability to have the resources, at least some resources, and to have people join us and try to help you. Joey Kane, thank you. Gifted 5 Justice Serve TV memberships. I don't know what you're going to do, Joey, with any type of graphic, with me calling, with me ranting against Judson Welcher because of his rant against the female forensic pathologist, who has a lot more credentials in calling a cause of death than you do, sir. I find you out of your lane. I find you causing the accident. And if Karen Reed gets convicted, I hope you never sleep another day in your life after you've said that. That's how I feel. And you know that I tell you exactly how I'm feeling here. And I hope you appreciate that, because I want to hear exactly how you're feeling. So with that, I am going to say, I will see you at 6 o'clock. Michael Bryant will be on. We do have the winner of the first Where in the World is Justice? Both the town and the case he's on. He's going to be doing, he hopes, 3 of those while he's away on this assignment, because we are investigating that case. As you know, we did last year, and we're trying to see where we are this year with some new information that's come around from an arrest in England and all. And we hope to bring a lot to you here on the channel, on the network. We will get to Where in the World is Stephanie. We are going to on Friday do something on Diddy at our 6 o'clock in the night show, maybe a half an hour on Diddy, half an hour on Reed, since Reed is also going to, obviously we're going to have the defense case, which I think is great. If I'm the defense case, I want it. I want that jury going into the weekend, not as Hank Brennan thought he was going to have, but going into weekend with something that is very strong for me, the defense. And I think it worked out really, really well. And we will see who the first witness is, maybe the first 2 witnesses are, and maybe we'll get a hint tonight from it leaking out. We'll keep our eye on Twitter, but I hope that you are all there with us with 6 o'clock tonight. And of course, at 8:50 tomorrow morning, I'm Linda Kenney Baden. Hit the like, subscribe, share button. Say it again. I'll hit the like, subscribe, share button and notify. And I will see you along with my great mods later on tonight, 6 p.m. Eastern.